to mention item number 42, my lord. Item number 42, my lord. This matter become infructuous matter. This matter may be closed.
Your name? H.A. Taylor submits that the petition has become infructuous and accordingly submits that he gets instructions not to proceed with the petition. According to the petition stands claims that would have become infructuous. In term orders is any stands with you.
Most of it. May it please the lordship. Then if it is a opposition in connection, item number 38 has been filed today. It may be called for it. Lordship, I beg to lordship, item number 27, lordship. Lordship, there is a settlement going on between petitioner and us. Lordship, another 4 weeks time may be required. Another 4 weeks time may be required for the end of the negotiation process. We have already taken consent from the petitioner side.
What is going on?
Process is going on.
What is the
Settlement,
negotiation against a
lordship-
state action?
Lordship,
How can there be a private negotiation in a state action?
as per the direction of the court, we have settled the dispute and
Very well settle the dispute. Let the petitioner come out there and say that. Let's see when the matter reaches.
But I beg to mention item 35 of today's
Hmm.
with the concern of the other side, lordship, we have sent a proposal for compensation to the finance department. Now, lordship, here, although finance is not a party, we just need 2 weeks time accommodation to speeden up the process, my lord, for the proposal for the compensation. I'm appearing on behalf of the health department. Health department has already sent the proposal, my lord. We have informed the other side.
It was said that it would be done by Mr. Beagle
Yes.
on the last occasion. What is wrong? This order was passed last year.
Lordship, now they have sent the proposal, lordship, for the.
Then the proposal was sent last time only.
No,
It was brought to the notice. When was the proposal sent?
on lordship, as per the report, it's 25th of October.
Then 25th of October.
So, lordship,
It has been submitted by the council appearing on behalf of the health department. That further 2 weeks' time is necessary for giving effect to the judgment and order. So, accordingly, list this matter again on 18th of November.
lordship, item number 6, lordship. Mr. D. Upamanyu, this is a matter where lordship, because of medical emergency, he had to go to out of station, lordship. So, lordship, I seek 1 week's accommodation. The matter can be taken up on next Monday, lordship. For the medical emergency, he had to go out of station.
It has been submitted that the council who is appearing on behalf of the petitioner on account of medical emergency is not available. So accordingly, list this matter on 22nd of November 2024. Not 22nd, 21st of November 2000.
The concern of the other side, I beg to mention item number 10. Only 1 week time may be granted for filing of reply.
For what?
For filing of reply.
Absolutely no. 2017 matter, you want to file a reply in 2024. We are approaching 2000. Let's not go to 2025. Come up with it.
Item number 1, what are no steps?
Yes.
My lord. In this case, my lord, the turn number 6, he has already left to other place, my lord. He is not
What?
interested in this case. There's
Let us see what is the case about.
there is an eviction matter, my lord. Your lordship, kindly turn to page, my lord, 39, my lord. Serial number 52.
Who are you?
My lord, I'm the secretary of my lord, the Utpalnagar Bhogar Union Committee, my lord.
Huh?
I'm the secretary of Utpalnagar Bhogar Union Committee, my lord.
Hmm.
We have, my lord, earlier we have filed a petition regarding my lord widening of the road, my lord. As per, my lord, can you see as per order at F35, my lord? 35, can you see, my lord? Page 35.
You want what?
My lord, widening of the road, my lord, there is some enforcement by the, my lord, by the, my lord, landholder.
Whose road it is?
My lord.
Whose road?
My lord, at page 39, serial
Dark
number
number 64 belongs to whom?
Lord?
Dark number 64 belongs to whom?
Belongs to my lord, this response number, my lord.
Huh? Then why you are not filing a suit?
We have not filed a suit, my lord. We have not
You file a suit.
But my lord, we have earlier filed a petition, my lord. That
Then?
is at page, my lord.
Hmm.
Kindly see, my lord.
Hmm.
At page 16, my lord. Page number 16.
Paragraph 15.
Yes.
In view of the conflicting stand taken by the parties which involve dispute of this court, is of the view that necessary exercise will be carried out for establishment here to find out the nature and character of the Sohit Park in Jotia. Shall with the assistant find out whether the road is a public or municipal or remand. And after giving it, you know, then
Therefore, my lord, no order has been passed, my lord. For a deputy commissioner,
so then why are you not filing a contempt? You want the same order?
my lord.
You want the same order?
My lord.
Are we sitting out here taking up matters of
No,
the
no,
matters
no, my lord, no,
to pass
we
the
have-
same order?
My lord, we have submitted.
You require reiteration of this order. Then it would be a case of contempt. Why have you approached this court?
My lord, we have submitted representation to them.
So what? If the representation is not being taken note of, it will be a case of contempt. How a repetition is maintainable? Yes, Mr. Vijay Talukdar, have you taken any action in pursuance to the directives
Yes, but
passed?
as per my instruction, it was way back in 2020 November. One portion of the road was encroached. Then there is direction to the circle officer by the deputy, additional deputy commissioner to evict that order.
Then what happened?
Thereafter,
Take instructions on this. What is that? The instant repetition has been filed. Being aggrieved by the inaction on the part of the respondent authorities in not complying with the specific directions passed by this court in its order dated 1/4/2019 in WPC number 2514/2017, whereby this court had specifically directed the establishment of the Deputy Commissioner Kamrup Metro to find out the nature and character of the Sohit Path in the Jotia area of the Guwahati city. The Mr. B.J. Talukdar, the learned additional senior government advocate, submitted that as per his instruction, there was certain communication issued by the deputy commissioner to the circle officer concerned for taking appropriate steps, but he is not aware of the present status. List this matter again on 11th of November 2024, on which date the state shall provide instructions before this court as to whether the directions passed by this court in its order dated 1/4/2019, or what is that? 1/4/2019, above mentioned, have been duly complied with or not. List accordingly.
It's on item 2.
Main thing, my lord. The things that matter in the compensation is that to be given.
Done.
The compensation is yet to be received. 2 months time, my lord, as per the last,
Lordship, here, Mr. B.
Instruction
Gogoi, he's on
is
legs,
P.
Lordship. He's on legs, Lordship, in court number.
Who?
Mr. B. Gogoi appears for.
What does Mr. B. Gogoi have to do?
Lordship, he's in court number 2, he's on legs, my lord, some medical
Last
efficiency.
time, Mr. DCK categorically said submitted that pursuant to the instruct, the matter has been cleared from the office of the and land presently lying in the office of the chief secretary. He further said that he will instruct the officials to do the matter, whether the petitioner have been disbursed the amount. That's a small thing. Why you are keeping this matter pending for such a
in
long
fact,
time?
in that last instruction, 2 months only time was.
Yeah,
Yes.
2 months time have been granted.
But, Lordship, I'm just asking for a timing, Lordship, we have the,
Do one thing, return the land.
Lordship, that is.
You want the morgue? Return him the morgue.
I think that only, Lordship, we tell, as the department is seeking for some time, Lordship, noted that instruction is with Mr. P.
2 o'clock.
Item 3, part heard.
The payment has been disbursed.
Disbursed? Yes. Last something has happened. Payment disbursed. It has been submitted by Mr. N. Hawk, the learned counsel appearing on behalf of the petitioner, that the payments, that the due payments to the petitioner have been already disbursed. He therefore submits that the petitioner have no further issue in the instant writ petition. Accordingly, the writ petition stands closed. Mr. Hawk, because of this court's intervention, at last you got something.
Yes, it is.
Otherwise, impossible.
I'm obliged, sir.
These people, they don't give you.
Yes, correct. Obliged.
Item 4, part heard.
The RO office, the office FCI has decided to file, to purchase directly, my lord, from the petitioner. So they have, for according a sanction from the headquarter, they have written letter to the headquarter. So matter may take another 10 days time because the delegation of power for purchasing the, direct
Mr.
purchase.
B.K. Singh, the learned counsel appearing on behalf of the FCI has submitted that he has, that the matter is being presently taken up before the higher ups for the purpose of directly purchasing the land from the petitioner. He therefore submits that some time may be granted in that regard. List this matter on 25th of November 2024 for further instructions.
Okay.
Item 5, part heard.
Yes, you don't have a case. Let us not dismiss on the first day itself. And let's list this matter again on 14th of November 2024. Interim order passed earlier shall continue till then. But on 14th, the winter vacation goes.
Item 7 and 8.
Yes, where is your person?
My lord, he's not came today, my lord. Any date, my lord, I fix my lord. Lordship, 7, 8, any date, my lord.
And why? Have you gone for a fresh advertisement?
Now in 3 papers, it has been issued, shooting for Adi and one from Contractor. And
And
8 is the last date for filing.
Still in the Boro language?
English.
Huh? English.
How English? But the stand, my lord, I have seen stand taken by DFO, they have denied whatever the newspaper has said. They have denied.
No, it's okay. Let us have the presence of that person concerned. We have asked the presence of this now.
Yes.
Direct the personal appearance of the manager. Uh, taking into account the order passed by this court on 26/9/2024 and the non-availability of this court on 22/10/2024. This court accordingly fixes this matter on 12th of November 2024, on which day the deponent of the affidavit filed by the respondent number 11 is directed to be present on at 10:30 AM before this court.
Only one convenience, if it is not inconvenient, it can be on 13th.
13th is okay. Okay, 13th.
And
Mr. Bora, kindly file an affidavit bringing on record the advertisement. In the meantime, Mr. S. Bora, appearing on behalf of the BTC, is directed to bring on record the advertisements issued for settlement of the two mahals in questions by filing an affidavit. Yes, what is this?
This is regarding land acquisitions.
Yes, your land has been acquired.
Acquired and the building has been destroyed,
Then what happened?
and they have paid some amount.
Ah.
I'm not agree with that, so I approach the arbitrator. So arbitrator has passed the order, but that order has not been complied with. The arbitration order is at page 34.
Page 34.
Page 30.
Then
Then feel that this rejection is pending. Only
but
the,
why should
only the
we,
ground,
but Mr. Counsel, why should we interfere out here under 226? This is an arbitration award. And if, as such, why you're not filing an execution application?
I have filed several times, but now arbitration is not here. Arbitration proceeding is not conducted.
Now, this is an arbitration award.
Award here, Lordship.
So once it is an arbitration award, you need to execute it before it is a decree.
No, when the
In
petitioner
terms of
has,
section 36, it is a decree.
yes,
If it is a decree,
but
then in that regard, you are to execute it.
but at this stage, I cannot.
Why?
Because there is no such provision. There is no arbitrator now.
Why do you have to go to the arbitrator? The arbitrator has already passed the award.
Arbitrator is not there, your Lordship.
Mr.
Already,
Counsel,
Lower Assam Commissioner was the arbitrator, your Lordship.
arbitrator has passed an award.
Yes.
After that, what do you do?
After that, I filed again the petition when that
No. If an arbitrator is not passing an award, he has already passed an award,
Yes.
you go for execution. You file an execution before the court of the district judge under section 36. Go there. This is how it can be worked out. See, have you got hold of an Arbitration and Conciliation Act? Sorry, state of affairs, Mr. Counsel.
Just get me time, your Lordship. Some instruction I have to take.
What instructions? Don't delay any further. After 12 years, your limitation goes. This award was passed in the year 2013. We are in 2014. 2024, 11 years have already passed by. So one more year left. Nothing remains. Why we're not going there? You'll get whatever may be. You have to go before the district judge. Where was this execution done? Borpeta, go before the district judge, Borpeta. What is all these things?
One of the petitioner expired.
Huh?
One of the petitioner before the
It's
arbitration
okay.
expired, so the
There is a material.
material is there. Already PWD has revalued. But even then,
They have made the revaluation.
yes,
Where is that?
that is an additional affidavit. you will say. Additional
This
affidavit.
is not the forum where it is. Where is the valuation?
Yes, additional affidavit. you will say, Page 5. Page 6 actually.
Where?
Page-
Your affidavit.
Yes. Calculation statement.
At page 49. Is that the one? It was done on 28/6/2016.
28, yes. 2019 euros.
Huh?
19,
Are we referring to Annexure H,
yes.
page 48? Yes. Why is the National Highway not paying? That is why I'm asking you. Why you are not paying?
Actually, I have got the letter from the department. They are not aware of this reassessment.
Huh?
They got the national authority.
Now you are aware.
After the filing of the case, Lordship, I have. informed
Filing of the case was done in
16.
2016. Then till yesterday, they were not aware.
Section 3A was issued 2005. 2005 laws.
What?
Under section notification under section 3A. So
Understood, but this is the assessment being made. You have not challenged the award of the arbitrator. You have not.
arbitrator has completely depends upon the deputy commissioner. Lordship.
Huh?
Arbitrator has said that in the award Lordship, that while fixing the valuation of land, the solution and other considerations shall be included as per direction of state government. Case 35.
The law in
So
this
what-
case is very clear that the assessment of the building needs to be made as per the present market value as on the date of taking possession of the competent authority. So the observations made while the ruling decision arrive, while fixing the valuation, the solution and other considerations shall be included as per the state. The valuation will be assessed as per the market value as on the date of taking of the possession of the acquired land, the competent authority shall the competent shall provide the specific date over to the email, the appeal petition is disposed of. So it has been done. Then
Whether it was assessed as per the market value of the taking of the.
that was provided by the competent authority. Competent authority is your officer.
Some joint. Some joint. revisions.
What is the joint verification? This affidavit was filed long back. This affidavit was filed in the year 2019. Then 5 years back, you have not given her a copy. No, copy was not given.
Notice on whether it should be in the notice or that we have given her.
But you should have inquired what has happened.
That's why the department, I have got the letter from the department. Lordship,
Therefore,
that they were not aware of this reassessment of this building. If you not see-
The petitioner herein, petitioner or petitioners, the petitioners herein being aggrieved by the non-payment of the dues or of its due, of their dues pursuant to the award passed by the learned arbitrator under section 3G5 of the National Highways Act 1956 have approached this court by filing the instant writ petition. This court have perused the award for passed by the learned arbitrator dated 7/10/2013, whereby it was observed that while fixing the valuation of the land, the solatium and other considerations should be included. In addition to that, the valuation of the building be assessed as per the market value as on the date on which the possession of the acquired land was taken. The learned arbitrator further directed the competent authority appointed under section 3A of small a of the National Highways Act 1956 to provide the specific date of taking over to the PWDB concerned. It is further seen that in pursuance to those directions, the PWD department have made the reassessment and arrived at a figure of rupees 10,36,000. This court has specifically inquired with the learned counsel appearing on behalf of the National Highway Authority of India as to whether there has been any challenge to the award passed by the learned arbitrator or of the learned arbitrator, to which the learned counsel submits that there is no challenge. However, she submits that that the National Highway Authority of India is unaware of this assessment being carried out by the PWD, as there has been no information provided. She, however, submits that she is in receipt of a copy of the affidavit in reply filed by the petitioner, and in that regard, wherein the assessment made by the PWD has been enclosed as Annexure H. The learned counsel therefore submits that she would take appropriate instructions in that matter. Accordingly, list this matter on 20/11/2024, on which day the National Highway Authority of India shall apprise this court as to when the amount so assessed would be paid to the petitioners.
Okay.
Yes, what is this? What are you challenging?
We are challenging the order dated 27/12/2012.
What?
We are challenging the order dated 27/12/2012.
Order dated 27/12/2012,
Yes, sir.
passed by the learned as to why recommendation. Why are you challenging this?
Because, Your Lordship, the order which has been passed by the authority is not under jurisdiction.
For
It's not
showing
authorized to
cause
pass that
against
order, Your Lordship.
prosecution under 85. You have to show cause.
Yes, sir.
Huh?
Lordship, that order has been passed by the respondent number 3, which is superintendent, Lordship. He is not authorized to pass that order under section 89. Lordship.
If this order is being passed, you are referring to the page 91 order? This order is passed under what provision?
Yes, sir.
This order is passed under what provision?
Under section 89, Your Lordship.
80
89,
of the,
some that 8,000.
then
Because under that, Lordship, that this kind of order could have to be passed by the assistant commissioner. Your Lordship. Whereas in this case, that order has been passed by the superintendent. Your Lordship.
So the order can be passed by whom?
Assistant Commissioner, Your Lordship.
Not by the superintendent. Why?
Because Lordship, section 89 says it's a.
Let's see. For the VAT Act.
That section has been quoted in page number 24 of our petition.
Page
Number 24, Your Lordship. I'm very sorry, Lordship, the Commissioner, Lordship, not the Assistant.
may either before or after the constitution.
Para 19, Your
of the
Lordship.
proceedings or specific. So you are challenging whose?
That 2712.
You are appealing for whom? The
13.
transporter.
Yes, Your Lordship. Only
Transporter.
The transporter.
You are the transporter. If you are the transporter,
We are providing logistics.
this is not an order of composition. It may be wrong in so far as Bharti, Airtel and all. I'm not concerned with that. But the fact that you have made forged documents.
No, Lordship.
However, kindly see page 90. However, in view of the admission confession of the transporter that the documents produced at the time of interception was forged, and also in view of the statement of the owner of the goods that such documents were forged, in spite of the fact that the original documents were handed over to the transporter, it is found that the committed the offense of knowingly preparing and producing incorrect under 85(1) N. And accordingly, it appears to me to be a necessary case for initiation against the transporter in respect of perpetration of offense relating to preparation and production of force as a so-called notice on the so proposing initiation, fixing year to be issued. The transporter has submitted a petition at serial number in which they have admitted the fact of being compounded against composition money of rupees demand being equal to the tax. Considering the fact that there is an interstate movement of demand and also keeping in mind that had the goods were allowed to be transported in Assam on the basis of the first set of documents found at the time of interception, it would have led to loss of revenue to the state. I am inclined to accept the amount offered by the owner as composition. Issue intimation to the transporter regarding acceptance of demand. So and so, Vice President has appeared and submitted a petition along with a draft for rupees demand composition money and has requested for release of the seized goods also. In view of the payment of AR money is dropped and the AR funds is compounded seized. Now, why are you aggrieved?
Because Lordship,
You have by your own self have made the payment. They have compounded. Matter is over.
Lordship, there is some forceful action done by the department. On that particular ground, we are required to file a reply. A short date immediately.
No. What is that short date? When was
Friday
the reply
night,
filed?
Lordship may kindly give them.
When was the reply filed?
Lordship, affidavit was,
You have filed an affidavit in reply.
no, Your Lordship, reply
Then
is not yet.
affidavit in opposition. Huh?
2020.
What?
2020.
What reply you want to file? There is no affidavit in opposition file. You want to file what reply?
They have served a copy of the affidavit. Your Lordship.
Huh?
This is our office copy, my lord. However,
You have not filed any affidavit in reply. Why are you aggrieved by this order?
the department has collected from us rupees more than 8 lakh rupees, and we we pray for refund of that amount, Your Lordship.
Why?
Because Lordship, on that ground,
You on your own have deposited this amount.
there was some.
You on your own have deposited this amount. Why did you deposit? Why did you submit and you have taken the seized goods? No. You have taken the seized goods also.
Kindly be taken on Friday.
Why are you challenging this order? You want a refund?
Yes.
You on your own have submitted this document. And what about you? You don't know anything about Helvetic, about your matter.
My lord,
You have not filed your reply also. It appears from the records that the writ petition was filed in the year 2017, but till date, the state respondents have not even cared to file any affidavit in opposition. It is further surprising to take note of that both the counsel for the petitioner as well as the counsel appearing for the respondent seems to have been oblivious about the matter. Taking into account that no interest has been shown in the matter by both the counsels for the petitioner as well as the respondents. Let this matter be listed in its usual course for hearing in the part 2 list.
11.
May I please, your lordship? Your lordship, in this matter, Mr. S. Upadhyay is appearing, your lordship. However, your lordship, he met with an accident, your lordship. He fell down from a running scooty, your lordship, and injured himself, your lordship. So I pray that the matter may be passed over for the day, your lordship.
Isn't it the case of that woman who have not got on account of this 3 lakhs? We are taking up the issue as regards her pensionary benefits.
Your lordship, I am unfortunately to state that, your lordship, I don't have any such
Then take your
instructions.
seat. Yes. PTC and you, both of you, what has happened?
Lordship, here the agency director had.
That I know.
Yes, Lordship.
Is present in the court and except the director is directed herein to resubmit the pension proposal as requested via the communication by the undersecretary to the government of Assam department at the earliest. Have you submitted?
Lordship, the papers have to be signed by the petitioner. She is not available in the last known address. That's why, Lordship, after her signing, it will be forwarded to the authority, Lordship. The DI was informed that she is out of state.
Okay. Can you inform your counsel
Yes, your lordship.
pursuant to the order passed by this court on 29, 2024? Mr. B. Chaudhary, the learned standing counsel of the BTC, has submitted that the Director of School Education, BTC, have not been able to resubmit the pension proposal on account of non-availability of certain signatures of the petitioner. The counsel appearing on behalf of the petitioner submits that he would duly inform the petitioner about the said aspect of the matter. Full stop. list this matter again on 25th of November 2024. In the meantime, the petitioner is given the liberty to approach the Director of School Education, BTC, so that the necessary signatures can be put in the pension proposals.
Lordship, she may approach the DI of Deputy Inspector of School because it's a secondary education.
It is directed to approach the Director of the DI
Deputy Inspector of School.
schools where
Lordship. Lordship, Lordship, it will be Pokraza.
the Deputy Inspector of Schools, Pokraza, for putting the necessary signatures in the pension proposal. List according.
May I please, Your Lordship? My lord, here is that my land has been wrongly converted into a government land, my lord. I paid for restoration of my patta, my lord. My lord, what happened?
Yes, government. Who is paying for the government?
On the last occasion, Mr. N. Goswami has time for taking instruction.
Yes. We have asked the government to obtain instruction as to what steps have been taken pursuant to the request made by the for making necessary correction of the land records. Chalo. None appears on behalf of the state respondents. Are you in a position to say about the district administration? Who is appearing? Yes, Mr. Henry. We have asked you to obtain instruction what steps have been taken pursuant to the request made by for necessary correction of the land.
We already been communicated on my lot. 24/9, but it was communicated to the Deputy Commissioner. I mean,
Then
my lot that they said that the matter, my lot, as per that. Kamrup Metro.
the matter pertaining to Kamrup Metro,
Lordship.
why? Where is the land?
But land at my lord, Moza Sayani, my lord,
The one
Is
letter
City
was
Gov.
given, my lord.
Moza Soyani, it will come under the this one, na? It won't come within the year, it will come in the Amingaon thing. Isn't it? Pakai Sindi Gaon, Soyani Moza. Soyani Moza will come in that.
That whole communication was 2019.
No, these are 2019. What has happened after I passed that order in 2024?
Before my lord, that's my lord, that, it was my lord, that letter was sent to the my lord Kamrup, rural my lord, that Aminga. My lord, we have to my lord, that communicate with the my lord, that Kamrup Metro.
It has to be pay for restoration of the KP Patta number 120 and so Gaon in favor of the applicant.
Sometime maybe consider.
What sometime? We have already given you 2 months. And you have not filed your affidavit also.
No.
Then what is wrong? Let us hear the Deputy Commissioner. It seems that government, you have not been able to pass appropriate direction. issue, get instructions. Let's hear the advocate, both the deputy commissioner, ask them to be personally present. Not done. Person's rights have been taken away. It is seen from the officer, from the order sheet, that this petition was filed by the petitioner. It is seen from the materials record that the petitioner herein have petitioners herein, petitioner herein being aggrieved by the action on the part of the respondent authorities in showing in the revenue records the land belonging to the petitioner as government land had approached the deputy commissioner, Kamrup Amingaon, isn't it?
Yes, madam. Page 18.
Amingaon, yeah, huh?
Yes, madam. Page 18, madam. Deputy Commissioner Kamrup. My representative.
This was when they had approached the deputy commissioner of Kamrup for necessary correction of the records. Full stop. However, having not been done, the petitioner have approached the concerned officials time and again. It is seen that in spite of those approaches, nothing has fructified. Full stop. Under such circumstances, the petitioner have therefore approached this court by filing the present petition, seeking a direction upon the respondents to restore the patta of the land of the petitioner by making necessary correction in the revenue records. The writ petition was filed in the year 2018, 6 years, and 6 years have passed by. In fact, there has been orders passed on 19/6/2024 and 29/2024, directing the state respondents to provide instructions as well as to bring on record and to provide instructions, which, however, have not been done. Today, when Mr. J.C. Hendig appearing on behalf of the state respondents, he seemed to be unaware of the actual state of affairs in spite of the orders being passed by this court. Taking into account the above, this matter on 13th of November 2024, on which day the district administration of both Kamrup Metro as well as the district administration of Kamrup Amingaon Rural are directed to bring on record their stand by filing an affidavit along with the necessary documents showing as to how the land of the petitioners have been converted into government land. List accordingly.
We have been directed to find an additional affidavit matter. The procedure is going on, file the affidavit matter today, matter. Because of the holiday, we did not file it.
It has been submitted by Mr. N.C. Das, the Lineage Senior Counsel, appearing on behalf of the Provident Fund authorities, that the direction to file the affidavit is in the process and would be filed during the course of the day. This matter again on 18th of November. The registry shall bring on record the affidavit if so filed during the course of the day. And
14,
yes, what is it? Who are you preparing for?
For the. That's over 2 to 5, madam.
What have you done? Why the petition filed?
My lord, the TTS was deducted from the petitioners, my lord, but that has not been credited against the PAN card of the petitioner. Petitioner is a contractor, my lord. And there
So
is,
who has deducted TDS?
my lord, the respondent number 225 BRO, Border Roads Organization.
Two. Also, they have deducted the TDS but not shown in
They
the
have not-
26 AS form.
Yes.
Now have they shown it?
That's what, that is information that has been rectified and the amount is. Pursuant to last order, my lord, of this court. They have paid the TDS amount that has been deducted.
And now you've done it.
Mal.
Now you have deposited. Why you are not taking action against them? Put them behind bars.
Yeah, lordship, they didn't deposit. Now they
Understood? If they are depositing now, there's a delay.
have to take action against the petitioner. So,
Forget about the petitioner. Why you are not taking against them? Because they are border roads. They are direct liable to deposit. So if they have not done, there is a provision in the Income Tax Act
yes, sir.
for taking action. So why you are not taking action? These are of the year 2000.
Okay.
8, 9, 9, 10, 10, 11, 11, 12. My goodness.
Or in fact, Malad, in our affidavit, file. Well,
Now, how will you, the
figure was
petitioner
misplaced.
show? Tell me.
So the petitioner is claiming the tax benefit and his some tax attended didn't stop. So we issue notice to him. Thereafter he approached the of the court. Now the border road said that they have correctly deposited. And I have to make inquiry whether it is reflected in 26. We can take action against the petitioner.
So you take action against, that is a separate cause of action. But the petitioner hearing is aggrieved by the fact that despite they have though made the deductions and shown it in their while payment of the bills of the year 2009 to 11, but they have not actually deposited. Now, how will he show in his returns that this is the, obviously, it won't be. So he won't get the benefit at the time of filing of the returns.
He submitted the petition report that notice it has been deposited in the account of the petition.
Rightly so.
Now they said they have deposited. Now we have to make inquiry whether that has been reflected in correctly or not. So, in month of October they have deposited.
They deposited only now. Then? And does it require for filing of a case? We impose exemplary cost on the BRO. How much is the total? 71 lakhs. So we put around another one crore to you. Yes.
The affidavit, we have, reason is given, Malad, page 75, Malad. First, what happened, Malad? The PAN number was wrongly put, Malad, that is the fault.
What?
That is why, Malad, incorrectly mentioned the PAN number, Malad, it is in the paragraph 7, Roman 7, page 75 of the.
There has been likelihood of incorrect mention of PAN number
Malad.
during filing of the TDS by the issuance. However, the same was not noticed by the petitioner and the same was noticed by the firm when the IT notices were issued. So what is his PAN number?
Well, actual PAN number is Malad, one figure, Malad, instead of 5, Malad, it should be S, Malad. That is the all Malad, inadvertent mistake, Malad, on the part of Malad. That is why, Malad,
But then also does it require the 3 years?
Malad, what happened during those time, Malad, he filed when the.
But did you inquire?
Malad.
You see, did you deposit in the name of the wrong PAN number? No, you could not have.
Exists in fact.
No,
Malad. That
under
is
such
the
circumstances,
understanding, my understanding, Malad.
Under such circumstances, these were various deductions made for the financial year 2008 to 11. 3 years.
That has
So-
been rectified now, Malad.
Understood. But 2008 to 11, these are various PAN numbers.
Malad.
So in 3 years, you did not inquire that we are not in a position to deposit.
Well, in fact, it was not even noticed by the petitioner as well. Petitioner, if he has immediately come and inform us, definitely that has been rectified immediately. It is come to his notice subsequent. Well, it's not a human error, nothing else, Malab. That is why, Malab, there.
Now you have deposited.
Now he has deposited the amount that was deducted from me, my lord, in those years, my lord. But I am also entitled to the interest part also, my lord, because it was deducted in since 2008 to 2013, my lord. The meantime, income tax department has also adjusted the demand from me.
So do you mean that I should write it down that you are entitled to interest in the prayer portion?
I have, my lord, let me.
Where is it?
I think it is there, my lord.
Why the petitioner shall not be refunded tax with interest as per section 244A of the Income Tax Act. No, Income Tax Act. These are refunds pertaining to the funds given by them,
Yes, my lord.
income tax.
No, had it been in
Now,
my-
what happens if he does not deposit? What happens when he doesn't? It will be somewhere in 194, no?
It's also the duty of the assessing.
This is done under contractual, no?
Yes.
It will be come under what provision? Deduction? This deduction is made under what provision?
Well, 206, I think, my lord.
Huh?
206.
206,
06C.
deducting to tax to furnish prescribed returns. Then where the assessing officer considers the returns delivered, the furnishing of tax and respect of payment of any income to the receiving house. Where? Huh? What is the consequence? Yeah, any person responsible for payment of any sum to any resident. For carrying out any undue work, including supply of pay in pursuance to the contractor that shall at the time of credit of payment or the payment thereof. Payment will be deducted in amount equal to the- So what are the consequences?
My lord, under 244A, my lord, I am entitled to get the refunds and along with interest. My lord.
What is the refund is there?
Given by the income tax department. If it is deposited in the IT account against my PAN card, had it been reflected at that time, I would have got my lord. But if, as it is not reflected for their fault, my lord. So my lord, there is a duty on the part of the assessing officer also to demand the same from the deductor, my lord.
But did you furnish the proper PIN number?
But I am a regular contractor at that point of time, my lord.
No,
Seven
you
bills
put
were there.
it as 5 instead of S.
Yes, my lord. They have mentioned it as 5 instead of S, my lord.
They have not mentioned here. Your document also shows so. Kindly see this document somewhere.
That is their document, my lord.
Then no. Kindly see this document. Yeah. Page annexure 10, page 38.
Yes, my lord. This is from 16A.
Ah.
That BRO has issued to us
Hmm.
after they have deducted the form.
Ah.
Tax, my lord. That's so.
Ah.
Their document, my lord. They have mentioned it.
Now, did you correct it? Did you
But
mention that it is
If it
incorrect?
is corrected, my lord, then my account will be, amount will be credited to my account.
When?
They have now done it, my lord.
No, no. When did you inform them that it is wrong?
My lord, there are several communications.
Yes.
I have informed them, my lord,
You first informed in 2019.
19, my lord.
Then, what are several communications?
2019, my lord.
Then, this was done in 2010. You informed in the year 2019. Then, why would you be entitled to? Nothing remains. Now they have deposited, matter is closed.
Income tax department will claim penalty from you, my lord.
That you know what to do.
This,
You know what to do. Hmm. Your
will-
basic case out here is that they have not deposited. You, for the first time in 2019, informed them. From your document, there's no other document. Then they realized that it was not F. You can only see.
yes, my lord.
It is
They
being
have thereafter
indicated that
communicated.
by the email has intimated the till data is deducted from so and so have not been deposited. It is in the PAN number of the email which tax was deposited by the visitor was not correct. The correct PAN number of so and so which is erroneously mentioned in 16A so and so. In the event that the deduction of IT so and so email was forwarded to you. The revised 16A is verified by audit authority and so and so. What remains? Your entire prayer is given. No.
During those ITR returns, when I filed my lord, I have shown this, that this was even deduction. But it was not credited as I was inquiring my lord, then income tax department.
Then only you informed,
Yes,
you
but-
were issued the 16A, you did not inform them. Yeah.
That is there. my lord.
No. Heard Mr. So and so, the learned counsel appearing on behalf of the petitioner. Mr. SKL appears on behalf of the income tax department. And Mr. UK Gusami appears on behalf of the Border Roads organization. The case of the petitioner hearing is that the petitioner is a contractor, is engaged in the business of. And in the case of the petitioner hearing is that the petitioner is engaged in the business of construction and development works. The petitioner performed various contracts with in respect to works under the respondent number 2. Full stop. In respect to those works, though the petitioner had received the amount, the contractual amount after deduction of tax, more particularly for the three financial years 2008 that's 09, 2009 that's 010, that's and 2010 that's 11. However, in the year 2019, when notices were issued to the petitioner by the income tax department, it came to light that there was no deposit made by the respondent number 2 of an amount of rupees 71,85,065, which was deducted from the bills of the petitioner. More particularly in respect to the three financial years 2008-9, 2009-10, and 2010-11. This aspect of the matter was brought to the attention of the respondent authorities by submission of various representations. It also came to light during the state process that in the previous statements which were earlier submitted was furnished by the respondent BRO, respondent border road organization. The PAN number was wrongly written as AAYF 59156R. which ought to have been AAYFS 9156R, all caps there. It is under such circumstances the this mistake having been realized both by the petitioner and the respondents only at a later point of time when it was pointed out by the petitioner. It is further seen that the petitioner being aggrieved by the inaction on the part of the respondent authorities in not correcting, not correctly depositing the deducted dues under the provisions of section 194C of the Income Tax Act 1961, have therefore filed the instant petition seeking writ in the nature of mandamus, directing the respondent authorities to make necessary corrections as regards in the records as regards the PAN number of the petitioner, and also for depositing the amount of rupees 71,83,788. In addition to that, the petitioner have also sought for interest in terms with section 244A of the Income Tax Act 1961. The instant petition was filed in the year 2021. During the proceedings, various orders have been passed by this court. Today, various orders have been passed by this court, inquiring as regards whether the amount have been duly deposited in the correct PAN number. Mr. U.K. Goswami, the learned counsel appearing on behalf of the BRO, Border Road Organization, submitted that in the last week of September 2024, on various dates, the amount of rupees 71,83,788 have been duly deposited in favor of the PAN number of the petitioner being AAYFS 9156R. And in that regard, have placed the various form number 16A evidencing the deposit of the said amount It was also mentioned that though the petitioner had claimed rupees 71,85,065, however, an amount of rupees 71,83,788 have been deposited in as much as the shortfall of rupees 1277 was not deducted by the department. Mr. UK Goswami, the learned counsel, have also placed before this court the details along with the 20 along with the produced before this court the instructions dated 30/10/2024, along with the form number 16A, which are collectively kept on record and marked with a letter Y. The petitioner would be entitled to take. No, you give a copy. Mr. UK Goswami has also submitted that during the course of the hearing, a copy of the said instructions, copies of the instructions collectively enclosed as collectively kept on record and marked with the letter Y have also been furnished to the learned counsel for the petitioner. So, taking into account that the amount of rupees 71,83,788 have already been deposited, in the opinion of this court, that the first prayer made in the writ petition no longer survives. The next question which arises is as to whether the petitioner would be entitled to interest in terms of section 244A of the Income Act of 1961. In the opinion of this court, that the petitioner only in the year 2019 intimated the respondent authorities about the incorrect PAN number in the
From 16.
form number 16A as enclosed as annexure 10 to the writ petition.
And there are four from 16A, annexure 8, 9, 10, and 11 pertaining to those 3 years. And may I point out one thing?
Yes. It is the opinion of this court that the petitioner herein would not be entitled to the interest in terms of section 244A. More so in view of the fact that section 244A is not applicable in respect to delayed deposit. Yes, tell me.
The Amit was judgment in this one, the Delhi High Court judgment is there.
My lord, I have personally page marked the numbers, my lord, page numbers, my lord. Lordship may kindly turn to page 17 that I have marked. Paragraph 31 there, my lord.
Yes.
My lord, I'm reading it, my lord. In the affidavit filed on 29th of January 2013, the respondents have stated that where the SSC makes a mistake in the claim of TDS in the e-return and the return is processed and the demand is raised, and subsequently the SSC rectifies the mistake and claim and files the online rectification application, the same is processed and on any
No,
excess
but
to the-
Mr. Counsel, this 244A is vis-a-vis a refund made by, to
That
be
is
given
here.
by the
It is
department.
here, my lord, because in circumstance when tax is deducted from me and it is, my lord, for some people it was not upgraded. My lord, not the reason attributable me, my lord. My lord, delay is a ground, my lord, I accept. Then, my lord, I am entitled to receive interest under 244A. This is what says, my lord. So in this judgment itself, my lord, where I am reading 31, that observation relates to this, my lord. I'll
The
take
paragraph
notice
31 is in an affidavit.
why I am reading that, my lord. It is connected to that paragraph. Lordship kindly turn to page 25 of the judgment. I have marked in, my lord.
25.
25. Sorry, my lord, 26. 26. Lordship will find paragraph number 57, Roman paragraph 4, subclause. As your lordship got it. With regard to the interest under section 244A, we have issued direction set out in paragraph number 31 and 32 that interest should be paid to the SSC is not in fault at all. Well, that is why this is the direction, and paragraph 31 and 32 is relevant.
No, now it may be a case of, now it's too late for filing a revised return also you can't file. Can you file? No.
I filed the revised return only, my lord. Now what they have done.
Now you filed a revised.
They have done it, my lord. I have filed my return showing that this was the bill I raised, I got the money, and this much is the tax deducted under 16A as it was given. My lord, inadvertently that number S was written as 5, my lord. But the refund I ought to have got from the income tax department was not credited to my account.
No, first of all, whether you are entitled to the refund or not, how do I know?
My lord, it is because the refund.
No,
income
have
tax
you
return I
enclosed
filed.
your income tax returns, which
Along
are
with
the
the
assessments which have been made, wherein it shows
No, my lord.
that that particular amount has already been, that you are, if that amount of this 71 lakhs would have been added to those financial years, you would be entitled to refund?
No, that I have not annexed along with the.
How
But
can this court say?
I'll not file any new return, my lord, now. I cannot be, my lord.
No, I'm not on that.
Yes.
Assessments have been done.
Yes.
Now, in those assessments which have been done, you have already, have you shown those assessments that if these amounts would have been done, then you would have been entitled to a refund from the income tax department?
I got it, the point, I got it, my lord.
Just for example.
But as I have not annexed, my lord.
2017-18, let us take an example, 2017-18. You have filed your return. If this amount would have been taken into account, you would have been entitled to 10 lakhs or 15 lakhs of refund from the income tax department. And if you have, but you could not get it because he did not deposit. Then obviously I could have said that yes, but that aspect is not here. Or did you pay a tax out there?
They have already adjusted that from me. Then only I have.
But did you pay in addition to that any further tax?
During those years, my lord.
You must have 100%. Then where is the question of refund? Yes, he should have been punished. Because if there is a delay, there is a mandate in which you are to do it within a particular period of time. If you don't do it, then you are to be punished. There is a particular provision. There is a
This
delay.
judgment only, my lord, I'm not sure, my lord. This judgment only says that this is the duty of the assessing officer to ask the deductor to credit the amount deducted in the against my PAN number, my lord. That was the direction given by this division bench judgment. Read it.
No,
Now-
that is what it has been done now, it has been done. That amount has been put. But the question is whether you are entitled to the interest.
One thing, my lord, if possible, my lord. Can you give me 1 week time, my lord? I will try to get those returns of those years, my lord. If
Absolutely no. Yeah, enough, yeah.
it's from 2019, my lord.
But nothing doing.
This says
No, I would have. But did you bring on record a statement to the affair that yes, this is the amount which have been deducted, and as such, I would have been entitled to this refund. But I'm not entitled to the refund because of the fact that he did not deposit. Then only the question of the direction as per 244A would come.
My lord, one more thing, my lord. Please. Lord, you will kindly turn to this page 61.
No more. Remaining is for the division bench, something is there.
Oh, my lord.
Never. Interesting. It's section 244A of the Act of 1961. Be applicable. In addition to that, this court have also taken note of that there are no other materials placed before this court to show that had these amounts which were required to be deposited by the BRO been deposited, the petitioner would have been entitled to the refunds. In addition to that, it is this mistake which had crept in only have been realized in the year 2019 by both the petitioner as well as the respondent via Border Road Organization. Accordingly, this court does not find any ground for for issuance of a writ for payment of interest in terms of section 244A of the Act of 1961. Accordingly, with the petition stands disposed. Be that as it may, it is, before parting with the record, this court, however, makes it clear that the disposal of the petition and the observations so made herein above shall not preclude the petitioner to avail such applications for refunds before the authorities concerned by placing the necessary materials before those authorities.
State
Public. Public.
Yes,
Well, it has not filed their affidavit. See, some has filed their affidavit.
What is this matter about?
They have sent the affidavit for vetting.
Some time is 10 days. We have. Okay. Send the email.
The state respondent, you are paying for?
For respond number, my lord.
356
and 8.
One and two is pending.
That I know. The respondent number, Mr. So-and-so appearing on behalf of the respondent number so-and-so submits that 10 days time is required for filing the affidavit. So taking into account the above, this matter again on 27th of November 2024. In the meantime, the affidavit will be filed by the same person.
This case, the architect really appear, my lord, is on next in court number 2, my lord. For time being, my lord. Who? Architect did not get this.
Here is this. What is this matter about?
Matter pertains to the
Eviction.
eviction of unauthorized occupants under the Act of 1971.
What is wrong with the order?
We're saying that the authorities has issued the notice in a pick and choose manner. There are other occupants also on the same space of land.
What is wrong?
My only submission is that before the authority, before the estate officer, we are not allowed to submit any written
Who
documents.
says?
Well, estate officer,
Who says? Forget about that. Did you submit anything out here?
the appeal.
In the, before the estate officer, you categorically say that you don't have the permission to remain in that land. What is your right to remain in that land? Tell me.
As such, I have no right.
Then, start over. What do you need, Mr. Architect Chaudhary? Is he going to give you some more moral boost up? He has enjoyed a lot. Enough. When you are vacating, how much time?
As and when
1
they-
month? Winter vacations? When?
the
When?
New Year will-
Huh?
in New Year.
No, no. New Year
Hello.
Eve.
But we have been in possession of the land since
Huh?
25 years. Madam. We are running a process.
So what? That day I pass order asking these people to be thrown out who have been there for 30 years. So what? The only sympathy you are going to get from this court is how much time? 10 days, 15 days, 20 days.
Whenever they initiate the process,
They have already initiated. The moment I dismiss your petition, tomorrow they are going to go. Are you not? Then, where is this?
Maligaon. Madam.
Oh, Aligarh.
Well,
Hello.
we have been of occupation of 370 square feet of land. They have issued a notice about for 90 feet of land. And other, my lord, I am claiming that, my lord, this belongs to the state government. And
Where have you proved anything?
I have not proved.
The hook. In fact, your this is 226. 226 is not maintainable. Anyways, let us not go into that question. Heard Mr. S.
as before.
This was the learned counsel appearing on behalf of the petitioner, Mr. S.K. Medi. The learned counsel appears on behalf of the respondent numbers 1, 2, and 3. Full stop. The instant petition has been filed challenging the order dated 25/4/2022 passed by the learned additional district judge number 1 Kamrup Metro in Miss Appeal number 19/2015, whereby the appeal filed under section 9 of the Public Premises Eviction of Unauthorized Occupants Act 1971 was dismissed. Full stop. From a perusal of the materials on record, it appears that the petitioner claims that since the year 1992, he has been running his business in the premises without any hindrance and objection from any of the authorities. The area of the shop premises is measures 370 square feet. On 5/1/2015, the respondent occurred, the respondent number 3 had issued a show cause notice upon the petitioner under section 4(2) of the Public Premises Eviction of Unauthorized Occupants Act 1971, for short the Act of 1971, with an allegation that the petitioner had been in unauthorized occupation of a premises belonging to the railways since the year 1992. Full stop. It is the allegations made in the petition that the petitioner wanted to submit the written statement, but the respondent number 3 did not permit to do so. and only permitted the petitioner to make submissions orally. Thereupon, the order was passed on 10/2/2015 under Section 5 of the Act of 1971, directing the petitioner to vacate the premises under occupation within 15 days from the date of the receipt of the said order. Mr. Viswas, your client should have come up with a better reason. In fact, the notice under Section 4 categorically says that you have to submit. Anyway, being aggrieved, the petitioner thereupon subfiled an appeal. The order is 10/2 or 10/2/2015 or 15/2?
10/2/2015.
Okay. Being aggrieved, the petitioner preferred an appeal under Section 9 of the Act of 1971 before the Court of the Learned District Judge, Kamrup Metro, which was registered as Miss Appeal number 19/2015. The Learned District Judge, by the order dated 25/4/2022, had dismissed the appeal. It is under such circumstances that the present petition was filed. This court has duly heard Mr. S. Biswas, the learned counsel, appearing on behalf of the petitioner, as well as Mr. S. K. Medi, the learned counsel, appearing on behalf of the respondents, and have given due anxious consideration to the respective submissions. This court have also taken note of the order passed by the learned district judge, passed by the learned additional district judge, number 1, Kamrup Metro, in Miss Appeal number 19/2015. And there appears to be no perversity or infirmity in the said order. Apart from that, the petitioner herein have failed to show a single shred of evidence showing that it has any right or authority to remain in possession. Any shred of materials. Considering the above, this court finds no reason to interfere with the order dated 25/4/2022, passed in Miss Appeal number 19/2015. Accordingly, the writ petition stands dismissed.
Motion.
Oh, did you get it? Something?
Lordship.
Yes, state government, why you are not doing anything?
Whether they have submitted or not. whether
Lordship,
they have-
petitioner was directed to submit few documents, but she is not well. So she could not, so Lordship will need further time.
Huh?
Further, some more time, Lordship.
You should go and get it. No, on one hand, the government out here, the union government as well as the state government have been saying that we are doing a lot for the pensioners. You are having a particular nowadays an app by which you can even see the face. You do need not apply it separately. And on the other hand, she's right. She's fighting tooth and nail for all these things. How much time?
It's done.
The counsel appearing on behalf of the petitioner submits that that the petitioner, on account of her ill health, could not submit the documents within the time as permitted by this court on 13/9/2024. She therefore submits that the petitioner requires another 2 weeks' time to do so. Full stop. This court, and accordingly, the petitioner is given the liberty to submit the documents within 15 days from today. Full stop. List the matter again on 16th of December 2024 to apprise as to whether, as regards the progress of the petitioner's pension.
18.
What is this?
Hello, I am aggrieved by the non-payment of the compensation amount.
What?
My land was taken by the National Highway.
Not be issue directing the respondents to pay the compensation as per the reassessment for the petitioner's demand. Then, you have not been paid the compensation.
Paid notice, our affidavit, we have been restated in there.
Then, what you saying
They
you
have-
have not paid?
They have received the amount, my lord, even then they did not pay the my lord, that landlord.
Not
my lord-
vacated? Throw them out.
Lordship,
Where is the
I see the affidavit filed by the respondent number
4.
4, lordship.
I, Santana Bora. Allah. So and so.
Paragraph number 12, my lord, we have clearly stated.
The total amount payable to the petitioner for the land measuring 13 lesser than the building value was ascertained as so and so. That it is admitted that the authority have acquired further 3 lessers of land from the petitioner in dark number so and so, and the total value of the land and iman. That with regard to the number so and so, and iman as the value of the land of so and so, or without any objection by sanction of them, already accepted, but the rest of the period is not admitted. Because of the additional 3 has been sent to the for approval. What is this additional 3G?
They have reassessed the property and the PWD executive engineer, PWD, page number 27. They have stated the amount of my building. So this is the amount I want from them.
How much?
33,96,104.
Where?
Page number 27.
And they are giving you how much?
They have taken my building value at 7,18,000.
How much have they given you?
They have paid in 2 installments.
So you have received that amount. Then why you are not going and filing in as regards the quantum? What are you doing out here? Goodness.
When they received the amount, my lord, they did not file any objection.
No, you want to do whatever maybe you go and file 3G5. But you cannot come out here and file a writ.
My lord, they have filed an objection. Then they have raised the amount.
Who? Who has raised?
ETC.
How can they ADC raise?
No,
My
they, no, they have,
goodness.
no, they
Has
have
the-
reassessed them.
Has the
Reassessed for
order
everybody.
under 3G1 been passed? And if the order has been passed under 3G1 and you have been given a particular amount, thereafter the ADC has no jurisdiction or Kala has no jurisdiction. It can only be enhanced by the year. Where's your objection? Huh? Page 34.
Yes, my lord. Then, my lord, they have reassessed the reassess for many people, not only for me.
That is wrong.
Have done on their own.
You cannot reassess. Once they have already sanctioned and they have attained finality, nothing further remains.
My lord, in the reply, the ADC has admitted that they have sent it for the approval to the National Highway. In page 57, paragraph 9.
Huh? Do. Have they vacated the land or not? Okay. Be happy.
They say that the entire, until and unless the entire amount has been not paid, my lord, will not be. Paragraph 7, my lord, we have stated that, my lord, that this much of amount we already been paid.
You are agreed out there. You have to do it in that manner.
My lord,
Anyway, he can wait for another. Throw him out.
because of, my lord, them not vacating the Indian, my lord, that.
There's an interim order. No interim order. Where's the interim order? This type of matters, they cannot be an interim order. No, there's no interim order. Throw them out. And we admit this petition. We'll have it after 10 years. And it will be dismissed then. Better 3G5. Think about it. No case. At the end of the day, you will be again having a big problem. You want the money, you have to get the money.
Lord, my only grievance is regarding the building value.
Understood. But who can decide that?
They have already decided.
They cannot. Once they have passed an award, an order under 3G1, he has no power to review.
My lord, we
There's a division bench order also.
don't know that award is passed or not, because we have made part payments. So we are waiting for the payment to come again. So they have made part payments actually.
They have already stated on affidavit that they are the total 13 plus 3 lessors of land and the building has been daily taken. So what remains thereafter? The only way is for you to file an appeal that it has not been considered. Hello? At the request of the learned counsel for the petitioner, let the matter be listed after 2 weeks.
Pending item 2.
Here the advocate general will appear, he is on late to put them on. If he is requested to take it after some. He will come, he is on the list.
Item 19.
File affidavit, my lord, it is not in record, my lord. My lord, that affidavit is, my lord, is a 3-page affidavit, my lord, I can give my copy also, my lord. There's not much in the affidavit also, my lord, I can give my copy also.
What is this?
Now, my lord, here is a case, what had happened here is, my lord. An NIT was issued, my lord, in response to the NIT, we have submitted our bid with 2 special conditions, A and B. And, my lord, they have accepted our bid without taking into consideration condition A and B. And further, they have tickled with their own condition. And then, my lord, when they have issued the letter of acceptance to us, we told them that it cannot be treated as a letter of acceptance. It can at best be treated as a counter offer or a cross offer, which we are rejecting. Because without those, we cannot. What they have done, they have continued pressed with the letter of acceptance. They have issued the purchase order, and eventually, my lord, since we have said that it is not binding on us, because neither you have incorporated my deviations, no, and moreover, you have
tempered with your own conditions. Then they have come up with this impugned order whereby they say, since we have failed to execute this work, therefore they will impose a penalty of 10% of the total purchase value, which is around 4 crore rupees. Against that, my lord, I have filed this writ petition. This is- Yes, ma'am. My lord will kindly see the NIT starts at page number 25.
It's okay. It was stayed.
Yes. Now, my lord,
Oh, it's a 2022 matter.
yes, ma'am.
What has happened to the work?
But it's complete, well. It's complete.
Somebody else.
Now, my lord, will kindly come to page number 34. Page 25 is the NIT, page 34, my lord. There is a price variation clause, namely clause 25, page 34.
Where is the NIT?
NIT, page 25.
Where is the entire line?
Page 25, it starts.
Finishes?
My lord, this is page 25, the index.
Where are the general conditions of the contract?
Yes. Page 25 is the tender document, page 25, and it runs till page 99. Now, my lord, may kindly come to page 34. My lord, have seen that price variation clause. My lord, is there at page 34.
No arbitration clause?
Now, my lord, in the railway contract normally there is an arbitration, but my lord, here, my lord, the issue is whether that can be treated as a binding contract or not, my lord.
So that is a binding contract or not, it is for the arbitrator to decide.
My lord, there
Why
is
should
no,
we decide?
there is no dispute regarding, my lord, any claim or whether work has been completed, not completed. There is no factual dispute in this case, my lord.
The factual dispute is as to whether the your offer, whether it was your acceptance or was it your counter offer?
My lord, that in my understanding, my lord, that would perhaps be a pure question of law, in as much as, my lord, to decide that, my lord, we need not, there are no facts are being disputed either by me or by them. Facts are admitted in this case.
Well, let's find the affidavit then. Let's get hold of the affidavit, we'll dispose it off as soon as possible. You have already a stake.
Yes. Till further orders, my lord. So therefore, my lord.
So there is, let them get the affidavit on record. You may like to file a reply, no reply, not necessary.
Because a copy has been served to me, I don't think it deserves any reply. Please.
It has been submitted that an affidavit has been filed by the respondents. However, the said affidavit is not on record. Accordingly, list this matter again on 12th of November. On which date?
13.
What?
12, 13.
Why? It's something very nice about
But
that week.
I'll pick up the other case or fix for another.
30 would be unlucky for the petitioner.
Like,
The 13th is another day, na? It's a motion day.
then 14.
Children's book.
Nineteenth of November. The registry shall bring on record the said affidavit. Mr. M. Biswas, the learned counsel appearing on behalf of the petitioner, submits that he has received a copy of the said affidavit. Liberty is given to the petitioner if so advised to file reply in the meantime.
20,
Advice you can, so don't use on next in code number 1.
Who?
My senior lordship, kindly pass about a matter for time being lordship.
Well, some difficulties on my part, but can it be taken up some other day, Miller? Have some physical ailments. That is why.
Okay. Mr. A. Samwa, the learned counsel appearing on behalf of the respondent numbers.
6.
Six submits that he has some difficulty today
inclusive taking into account the above list this matter again on 13th of November 2024.
Up to 16, I am not there. But fix it
You are
to
here today, na? Then let's hear you. Let's hear you and complete it, and then we'll hear the other side on 13th. Okay, you argue the matter. What is the case about?
settlement of fishery matter. The fishery that is that was settled with me. And the comparative chart, your lordship can find at page 37 of the petition.
Your name?
Pardon, I'm the respondent 6, Miller.
What is your name?
The name of my society is number 29 Nekera Lekera Mean By Committee Limited.
Your name is not featuring out here for 29, fishery name.
Yes.
But who are you?
We are a Samavai Committee, Miller.
Where is your name here?
We're in the list,
On the list?
in the second page, Miller.
Which one?
Page 4. It is the name of the tenderer shown as Niranjan Roy. That is,
You are Niranjan Roy.
Niranjan Roy is the secretary of our society.
Then
Then the address, then the amount, we stood first. Then the next column, yes, then number 29, Nekara means home by something. We stood first. There is no dispute. The question is, the whole thing, the petition stands on three counts, the three arguments. That Milord, according to the petitioners, some of our members in the society are not actual fishermen. They have given 3-4 names. We have replied to this. Out of those 3-4 names, 3 persons were discharged from the membership of our society prior to participating in the tender process. And the same situation had happened with them also. There are also 3-4 men in their side. We are also not the actual fishermen. They do some other job, but they also release them before from the society before participating in the tender process. So this point, my lord, I believe needs no consideration. Then, my lord, one Bakija clearance certificate has to be adduced along with the tender process. We have adduced, but the Bakija certificate, as your lordship can see, the name of the tenderer in the comparative chart itself is shown the name of our deed and secretary. This man has died later on. Now it has been taken over by a different man. We have in our reply, in opposition, we have reduced those resolutions and all. He died after the participating in the tender process. Then below that Bakija certificate, though issued in the name of the general secretary, deed and general secretary of the society, but he applied on behalf of the society only. But
in their case, what type of, they are also societies.
they are also society.
Who are they? What is their name?
That is their name in the first page, my lords. At page number 3. Their name is Tepuri Sonai Morikuti Mean By Committee Limited.
Temporary Sonai,
Tepuri Sonai, 3638.
So their Bakija notice is in whose name?
Their Bakija certificate they have not reduced.
In whose name?
That is we do not. We don't have that information. Now, my lords, whether Bakija certificate is at all required. If this point lordship decides, my lord, there are division bench judgments of this honorable court. You said, my lord, that Bakija certificate is an empty formality. If they have complied with everything, all other things, then Bakija certificate, if it is issued even in the name of the some other officers, or it is not adduced at that time, they have adduced it later on, then also it can be considered.
Those judgments of which year?
It's of late, my lord Justice Tulia and Soumitra Swekam.
Huh?
My lord Justice Tulia and Soumitra Swekam.
So this has to be before 19?
No, this is 2023. 2023. They have considered the notification of 2019. They have, as your lordship may, perhaps so. This is the only things, my lord. Rest,
And the third point,
third point, my lord, distance. Distance. We are the Parvakinda, means we live on the bank. And from that document itself, your lordship can see that there we are residing, their distance is 2.3 kilometers from the bank of the fishery. And our distance is over 0.46 kilometers. Means even less than a kilometer. We reside on the bank, which in Assamese it is called Parvakinda. Lordship can see at page 38, our distance is 0.460, 0.640. And their distance is 2.3 kilometers. This judgment, the lordship may allow me to read out. Paragraph 3, 13, 14, 15, 21, 22, and 23. These are the important.
the division bench held that the Bakizet certificate is an empty formality.
No.
Yes.
My lord, in this case, we have challenged the settlement order made with respondent number 6, primarily on 3 counts. First point is, my lord, the respondent number 6 society is not consisted of 100% exemption. Number 2, the Pakizai clearance certificate is in the name of the secretary, individually, not in the name of the society. And thirdly, my lord, we say that the settlement is done for under political pressure. So if your lordship would kindly permit me, if your lordship would kindly come to page, especially
If it is political pressure, then the allegation of malafide has to be there.
Now, if your lordship would kindly see respondent number 8 to 12, what they are of the respondent number 6 society. Please come to my lord, page 39 of the writ petition. 39. This is a reply file given under RTI Act.
Yes.
With reference to the subject cited above, the required information as sought for from your end under RTI Act in respect of Morigaon district are as under. ELCM data of Anjit Kumar Bhomik, that is R8, my lord, may be seen in the official website link of Government of Assam. The data enlisted in the name of Holodhar Bhomik and name yet to be replaced to so-and-so. The ELCM data of Anjit Kumar Bhomik is enclosed herewith. So, my lord, he is having a fair price shop. But these are the data from which it is evident. Then this Poritus Das, respondent number 9, is a hawker of SK oil. Then my lord will kindly come to page number 66. Respondent number 10, my lord. He is a ward member of Buraburi Gaon Panchayat. Respondent number 10. Then my lord will kindly come to page 69. This respondent number 11, he owns a grocery shop. So lordship to kindly come towards the bottom. Aforesaid man under Moza Mayong is running a fair price shop.
Respondent
the-
number 11 is some Chandan Bhumik,
Yes, Tondan Bhumik, my lord.
and here 69 and 70 is some Ajoy Bhumik.
If your lordship would kindly come to the vernacular at page 70.
Hmm.
Ajoy Bhumik, this is to certify that Ajoy Bhumik and be উপরোক্ত ব্যক্তিজনে মায়ং মোজাৰ হিপ্ৰাং বজাৰত কাপোৰৰ দোকান কৰি থকা দেখা যায়।
But how is Ajoy Bhumik connected here?
He's a member, my
Oh,
lord.
he's number 12.
Yes.
Who is 11?
11.
Chandan Bhumik.
Yes. Chandan Bhumik, my lord, page number 69.
Mr. Somoa says that he does not deny that these persons are not 100% fishermen. He doesn't deny. No. His submission is that prior to the submission of the bids, these people have been removed from the society. That is his submission.
No, my lord. These are the information we have got under RTI file after filing of the, after submission of the bill.
No, but is this,
Kindly see the date of the RTI reply.
no, understood, but
Yes.
does this RTI
Yes.
say
Huh.
anything as regards them being the members of this society?
The member list is there, my
They
lord.
are still holding those for business. That is why they were removed. They were
Yeah,
removed
definitely,
prior
yeah.
to the participating in this tender.
Thank you.
RTI after the tender proceedings will definitely say that situation only.
How can that say if you have removed them? Please come to the members list, my lord.
Well, 104 is my reply. In my reply, page number 104, this is the resolution that these two persons were removed. 104 and 105, these three persons. Resolution number 10. The same situation in their case also.
Member list from the page 130. If your lordship would kindly come to page 130, my lord, in the affidavit in reply.
Yes.
Yes. My lord will kindly come to page number 151.
151.
List of members of number 29, Nekara Nekeri means Samabhai Samiti. Serial number 20 is Pratish Bhumik. Then my lord will kindly come to page 152. Serial number 23 is Chandan Bhumik. Serial number 26 is Govinda Bhumik. Serial number 42 is Ajoy Bhumik. So their names very much appear below.
Well, this
No.
list is of
When did you
2020.
get this thing? This,
This list is of 2020, Miller.
how did you get this list of 2020?
Page.
This list of 2020, we have removed it from 123. These are not relevant documents. Kindly see it signed by Niranjan Roy, this is Secretary of our society.
My lord will kindly come to page 156 is the vernacular and 155 is the translated copy. On 23/8/22, this information was provided. 23/8/22. সম্মানপূর্বক বিনীত নিবেদন যে উপরোক্ত উল্লেখিত প্রসঙ্গ চিঠি মতে আপুনি বিচৰা তথ্যসমূহ কাৰ্যালয়ৰ নথিৰ মতে আপোনাৰ জ্ঞাতাৰ্থে পঠোৱা হ'ল। Page 156. So on 23/8/22, my lord, this was the information which was furnished.
And this list itself says that this is members list of 2020.
21/10/2020.
He was removed thereafter, March thereafter. This document is not removed. And we have not denied that they are doing other work.
Okay, the next question is.
And next, my lord, this is very vital, my lord, that Bakijai clearance certificate. If your lordship would kindly come to page 84. Sorry, not 84. Bakijai clearance. Yes, I'm sorry, my lord. In page 93, the affidavit opposition filed by them. Page 93. Page 75. Sorry, my lord. Page number 75, I'm sorry, of the writ petition.
Yes.
Now, along with the tender, this is the document they have annexed. This is to certify that as per records available in this office, there is no Bakijai case against Niranjan Roy. So, well, Niranjan Roy is nobody. It is the society who has, submitted the bid.
And what is your Bakijai certificate?
Yes. I'm going to check on it. Makan di sana. Reply dasar ini. Ours is not given, Milord, that question is not arisen. And as per the comparative statement, there is no defect in our thing.
No, in the comparative statement, they also didn't show any defect in their thing also.
So if your lordship that we can bring it on record, sorry, you can get it on record, Milord.
Because if we see page 95,
Yes.
these are all being given in the name of, your name is who?
We are the society, Milord.
Harilal, no. You are Maharaj Das.
Morihuti means formed by committee.
Empori Funai Committee.
Maharaj Das is the secretary.
Their name also showed as a tenderer in the comparative state. Tenderer is not shown, the committee society is not shown as the tenderer. The secretary is shown as the tenderer.
How can it be? It's a 60% fishery. How can an individual participate?
No, I am talking from the Annexure C. I'm not saying from my own. Annexure C says the name of the tenderer is shown as all the name of the secretary. Their secretary is also named.
No. Please come to the fifth column. 1, 2, 3, 4, 5,
is there.
7 column.
That is there.
Apori to be Arya Dablong 38 Tepara Teperi. Name of the cooperative society is there.
That is there, but name of the tenderer is shown as the name of the secretary only. And whether package certificate at all is required, my lord, in view of the dividend bench.
No, my lord, there is a separate division bench as on this count, my lord, the settlement has been interfered also. And my lord, if your lordship would kindly come to page 84, that is the gazette notification published by Government of Assam.
Page 84.
Page 84, yes. And the relevant portion at page 85.
This is the notification of 2018.
Please come to me, lord.
Point 4.
No. Now, why it had to be issued, my lord? There is a purpose. A lot of anomalous discrepancies have been observed while verifying the tender documents forwarded by Deputy Commissioner SDO pertaining to settlement of 60% government fishery by government in the fishery department. As a result, most of such settlement orders are challenged by aggrieved parties before the Honorable High Court. It is therefore felt that there is a need for streamlining the procedure for submission of information document with the tender so that there is uniformity in all such tenders, though notice inviting tender floated by the to maintain transparency and avoid legal complication. So basically, this is the purpose, my lord, why it has been issued.
Now please come to me, Lord, serial number 4. Bakizai clearance certificate. Bakizai clearance certificate is to be furnished by Bakizai authority under the concerned deputy commissioner, where the society enjoys registered
Name of the society,
society.
not in
And
the
not
name
in the
of.
name of office bearer of the society. My lord, had it been a case, Narayan Day, secretary so and so, then also things would have been different. It is in the individual name. So therefore, that is, my lord, there was nothing before the authority to make an assessment whether he is a defaulter or not. On what basis government, my lord, came to the conclusion that he is not having any Bakizai proceeding or the society is not having. So there was no material. It's my humble submission, it is settled.
The matter is very short. Okay, what does the government have to say?
If I may be allowed to, my Leonard friend's submission as regard the notification is it's okay. But this judgment that I have just given to your lordship, the division bench judgment which was rendered in 27/4/2022.
But Mr. Samua, tell me one thing. Does this division bench judgment take into consideration this notification?
That, my lord, is not reflected here from. But
Not reflected therefore. There are two aspects in the division bench judgment. First is the aspect wherein the division bench judgment looks into as regards the necessity of the Bakizai proceeding, the certificate, one. Second is based upon another judgment of 2011. You have to also consider 2011 judgments which were being pronounced were pronounced much prior to the, much prior to the various judgments of the Supreme Court, which says that the authority concerned is the best authority to judge as regards the requirement of that. So at that point of time, those judgments were mostly being influenced by Poddar Steels. So
and
this,
by virtue of CCL case, my lord, Poddar still has lost its certificate.
so the question of mandatory, directory, all these things are there. Now, therefore, the question which is before this court as to whether in acceptance of their Bakizai certificate, they have in fact not complied with the notification of 18th of January 2018, or the government thinks that we don't require the Bakizai certificate. I think the government stand would be the best then. Let us understand that.
Well, only one thing, my lord, there's a division bench judgment that happened. That this notification would be relied upon was not indicated in the tender.
That is what I am saying.
That division bench judgment, my lord.
Justice?
Chief Justice and Justice Suman Shah. New
Oh, that
judgment.
is another one. no?
Yes.
Ah. Because the other one is by Justice Dhulia and Sumitra Sekia.
Ah.
So in that, they have not taken into consideration this notification.
Here I relied upon that BK Srivastava's case. The moment it is gazetted, then it is for information of all. Therefore, one cannot plead ignorance. Para 10, my lord, 10 and 11. Here, amongst others, one of the point was that since it was not made a part of the NIT, whether it can be relied upon. Para 10 and 11.
Here, however, the division bench did not take into consideration this Pugwal, where it says that a Bakija certificate is not necessary.
Anyway, so judgment, we can say, but then Bakija certificate is relevant because that will show the status of financial position of the society. If it is a defaulter, then they are not entitled.
In Pugwalpur, another very important aspects have been taken into consideration by the division bench that yes, Bakija certificate would have been of importance had there been an allegation that this particular society has been a defaulter. But there was no allegation as such. That was another aspect.
But here in this tender also there is a condition,
Huh?
Tender also there is a condition
Yeah.
that the Bakija clearance is required.
Yes, government, who is the government?
Regarding business.
In fact, one second. In fact, my lord, today we could lay our hands to a document. They owe my lord 13,46,650. This respondent number 6. If necessary, my lord, today we have got it. 13,46,650.
Do one thing. You file an affidavit.
Additional
bringing-
affidavit.
No, bringing on record your.
My Bakija as well as this. Well, will do.
Because if this is being done, then this will take care of Pugwalpur.
Yes, yes.
Save,
Kindly give me
save this code from embarrassment.
7 days time, we'll file it.
The instant petition has been filed challenging the settlement of the fishery, namely 29 number Nekeri Min Mohon, in favor of the respondent number 6. The challenge made to the settlement made in favor of the respondent number 6 is on 3 folds. One, that the respondent number 6 does not have 100% fishermen in their society. And in that regard, Mr. K. N. Chaudhary, the learned senior counsel appearing on behalf of the petitioner, have placed on before this court various documents to show that these very that the society had for 6 members who are the respondent number 7 to 12 who are not
5 members. 8, 9, 10, 11, 12. 5
members who are not engaged in as fishermen but have other have other vocations. He has also referred to a list of members wherein the membership of the respondent numbers 8 to 12 have been shown against the membership of the respondent number 6. Mr. Asa Moore, the learned counsel appearing on behalf of the respondent number 6, submits that even prior to the submission of the tender, these respondents numbers 8 to 12 have been removed from the society, and as such, the fact that the allegation that the respondent number 6 society does not have 100% fishermen is totally misconceived. Number 2, the second ground of attack to the settlement made in favor of the respondent number 6 is that the respondent number 6 has submitted a Bakija certificate that the respondent number 6 did not submit the Bakija certificate as required as per the NIT. The learned senior counsel appearing on behalf of the petitioner submitted that the certificate which was submitted was a certificate of one Niranjan Roy, one Niranjan Roy, and not of the society in question. So in that regard, the learned senior counsel have referred to the notification, the gazetted notification dated 18/1/2018, issued by the additional chief secretary to the government of Assam, whereby it has been categorically mandated that the Bakidai clearance certificate has invariably to be in the name of the society oblique NGO oblique SHG and not in the name of the office bearer of the society oblique NGO oblique SHG. Houston. The Learned Senior Counsel further submitted that it would have that the said certificate could have at best be accepted if it was mentioned that the certificate was issued to who was issued to Sri Niranjan Roy as secretary of the said society. But there is no mention whatsoever. Under such circumstances, without the said certificate, it would not only be in violation to the NIT, but also the notification dated 18/1/2018, and as such, the impugned settlement made in favor of the respondent number 6 is required to be interfered with. During the course of the hearing, this court made a specific query with the Learned Counsel appearing on behalf Learned Senior Counsel as to what about the certificate of the petitioner. He submitted that inadvertently the said certificate was not brought on record, and as such and further submitted that an additional affidavit can be filed, bringing on record the said certificate. The third ground of attack to the
Foundation is not there.
Huh?
Mass foundation is not there in the petition regarding the third.
Which?
Regarding that,
I'm putting it.
yes,
The third ground of attack to the impugned settlement is that the impugned settlement has been made to favor the respondent number 5, 6, and it is politically motivated. This court had put up a specific query upon the Learned Senior Counsel that if such is the allegation, wouldn't it be a case of malice in fact, and as such, the requirement of arraying the necessary parties in person would be required. The Learned Senior Counsel fairly submits that the pleadings are inadequate in that regard. Taking into account the above, let's this matter again on 19th of November 2024. In the meantime, the additional affidavit be brought on record. So the government advocate is further directed to place before this court the records of the case of the settlement on the next without pay.
21,
24, I'll be not there. Could it be either 25th or 26th? 19th. Actually, there is a marriage in the family. I'll go to Uttar Pradesh, Varanasi for 3 days.
21?
Not man, I'll be out from 21 to 24. Any day after that.
You are out from 21 to 24. I'm fixing it on 19th.
Yes, 19. 19.
এই দুখন ইয়াত ভৰাই দিব হে Yes. Tell me what is the case?
Regarding burial ground.
Huh?
Burial ground.
What?
Babastan community.
Not be issued directly to take proper and fast action against representation submitted by the villagers of here with the help of the petitioner. Huh? What is this? What is your case?
The petitioners are the resident of Zaperikosi village, and they are occupying one a government land for their burial ground also.
Who?
The petitioners.
Huh?
Petitioners.
You are occupying government land.
Yes, sir.
Then?
For burial ground. Thereafter, let's say the respondent 4 to 8.
Huh?
They are occupying our burial ground on the pretext that the government authorities allotted this particular land in their burial ground.
And then?
And thereafter, Lordship, we have approved the respondent authorities regarding the, but this particular land is within the jurisdiction of sub-area proceeding.
What is the right of the respondent number 4 to 6, 4 to 8?
428.
What is the right?
They are from another village, Lordship. So they occupying our burial ground.
File suit. What is this? Don't come out. These type of repetitions, you are spoiling time. Don't file suit. Goodness, that is why nothing is happening.
But
No, nothing will happen in this case.
their pretext is that Lordship, the land is allotted by the respondent authorities to them also.
So, if the land has been allotted to them, what is your prayer? Show me what is your prayer that your representation should be
Lordship, we have
timely and adequately disposed of.
Yes, Lordship, we have approached the respondent authorities to with a prayer to
You want this court to be a postman. So what? You have a right, assert your right. If you don't have the right, don't come up with this court and say that, okay, the representation is at the last, something to that effect. And this court is absolutely not in favor of directing authorities for disposal of representations. Representation, you have to have a legitimate right. You have to have a legitimate expectation. Then, you have any problem, file a suit. Any right you have taken over the entire land, used it as Dekarga and have not allowed the people of here to use it for their disease, then it is absolutely a civil suit. Leho. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Ms. So-and-so appears on behalf of the respondent number 2 and 3. And Ms. So-and-so appears on behalf of the respondent number 1. Full stop. The petitioner herein, the petitioners herein, which is a social organization, have approached this court by filing the writ petition being aggrieved by the inaction on the part of the Deputy Commissioner, Dorong, in not considering the representation filed on 25/4/2022. It is relevant to take note of that the dispute between the petitioner as well as the respondent, private respondent number 4 to 8 is purely a private civil dispute. Also, under such circumstances, the question of issuance of any direction to the Deputy Commissioner to consider the representation, or for that matter, passing any appropriate orders in the proceedings under Article 2 to 6 of the Constitution does not arise. Accordingly, this court finds no merit in the writ petition for which the writ petition stands dismissed. Be that as it may, this court, however, makes it clear that the dismissal of the instant writ petition shall not preclude the petitioner or any of its members to file to approach the civil court, provided the same is maintainable in law. Contractual dues. Ms. Ardeka, the learned counsel appearing on behalf of the Water Resource Department, submits that an affidavit in opposition has been filed today. List this matter again on 27th of November 2024. The registry shall bring on record the said affidavit. In the meantime, the petitioner would be at liberty to file the reply if so advised.
23.
24 also, sir.
What is that matter item? What item is it? 23, 24,
23, 24, 26.
only 25 is not there.
No. 24 and 26, your lordship, we are going to file within 1 week, your lordship.
No. Why you are not filed?
affidavit from 21 and 22. Affidavit is from 21, 22.
21,
And 22 and 23.
22 and 23 affidavits have been filed. And in 20,
26.
they have not filed affidavit. So and so, it will fix on, we should list this matter again on 4 and 26, list the matter again on 27/11/2026. In the meantime, the Water Resource Department are directed to file the affidavit on or before 11th of November. Full stop. The petitioner thereupon would be at liberty to file the reply.
Obliged.
25.
Please, your Lordship. Lordship, matter may be adjourned for the day as learned counsel KLR Yanthan is out of station because of her father.
Who is out of station?
KLR Yanthan, Lordship. His
KLR
her father is
Yanthan.
admitted in the
What is this? What is your case?
Case is regarding land acquisition and compensation claims, Lordship.
Then compensation not paid.
They have actually acquired the land without taking the proper survey, without doing the proper survey. I'm just telling
You
you.
are challenging a notification.
Yes, Lordship.
Under?
Notification dated 24/3/2022.
Notification under what provision?
Lordship, I don't have the file with me. I just went through the gist of the case.
Where is the notification? Yes. Madam, I'm telling you, this court
Is it
does not look
Is
into all
it-
these things. Huh?
Annexure A is the notification.
Annexure A,
Is it?
notification under section,
But it is under section 3D, my lord.
why they are challenging?
But page 24, my lord. Serial number 173.
Why they are challenging?
Payment of compensation to the, my lord, that particular person, Engtong Bay, my lord.
Hmm.
Claiming that land belongs to her, my lord. And the certificate submitted by the petitioner is in respect of the PP number 30 of different villages. And during the inquiry, petitioner submitted the original periodic patta, my lord. And we issued notice to the particular assistant revenue officer and all the persons whose signature is there. And they submitted in writing that the document is pulled, but that is not the signature. So we are now in processing that to send it to the forensic science laboratory about the signature of the particular patta submitted by the petitioner to us, my lord, and the specific specimen signature of those persons whose signatures are there, my lord. And as per records, my lord, there is no periodic patta was issued to the petitioner.
But tell me, can the competent authority decide all these things?
My lord, it is by the joint secretary, my lord, revenue, not by
Does
the
the joint secretary have the power to decide?
My lord, regarding, my lord, of whether the patta is issued to or not, my lord, he has the power. Revenue
Okay,
secretary
That he can decide
Madam,
that as to
madam.
whether the patta has been issued.
issued or not.
But you are appearing for whom? The competent authority.
I'm appearing for the joint secretary also, and the Kala is not made a party here, and the joint secretary is made a party here.
What is the joint secretary doing?
Joint secretary, Department of Revenue, respond number 7, page 5.
What is he doing?
And he is also the Kala, my lord.
He's also the Kala.
Kala.
So therefore, how can the Kala decide all these things?
It is, my lord, the Kala is required to, my lord, ascertain, my lord, whether the patta of the petitioner, when she claims that the land compensation was paid to the another person, my lord, under section 3H3, my lord, regarding apportionment and all this power is there. So during that proceeding, the petitioner
If
was.
you have any difficulty in finding out, you are not to decide. It has to go under 3H4.
My lord, regarding the, when we found that the patta is not genuine, is a forced one. So, my lord, authority of the Karbi Anglong Autonomous Council have the power to send it to the forensic laboratory.
You
The
do
police-
whatever you like.
My
That is a different thing. But as acting as Kala, you cannot touch
My
anything.
lord, a Kala is not a
When
party.
there is a dispute between two parties, then as regards the payment of compensation, it is for the court to decide. You cannot decide that because you don't have the power to decide that. You are only an authority to look into fundamentally this aspect.
My
In
lord,
fact, these days I was sitting in Aizawl, only one type of case is there, that is land acquisition. Land acquisition, land acquisition, land acquisition, and nothing else.
the question of apportionment, then the power is there with the Kala, my lord.
No. If you see
The lordship,
3H3,
your lordship judgment is there also, my lord. That particular, but lordship has decided in
3H3,
the
if
regarding
there
the-
is no dispute,
in the Dibrugarh Tea State, lordship has already decided these issues, my lord, regarding the, discuss all this.
no, if there is no dispute, you have the power.
Yes,
But moment there is a dispute, it has to go before the court.
your lordship decision is there, I have already gone through it.
So therefore, if they are claiming A, that they are entitled and some other person is there who is entitled, then the Kala cannot do so anything. It has to refer to the court.
So, my lord, another patta, not this particular patta, my lord. We have acquired the land, my lord, of this particular person, of this particular patta and particular dog. And the petitioner.
Her land is some other village.
Other village one.
So therefore, she has to go under 3H4.
My lord, my lord. My lord, then
She cannot
refer-
come here,
my
na?
lord, there is another point, my lord. Regarding reference, who will make the reference? The Kala will make the reference or the particular person?
They
will
can
refer-
go. They have the option of
But
going there.
in the Assam Mala, my lord, there is a circular that the deputy commissioner or the like that way, they would refer it to the.
Assam Mala is again another problem,
My
but
lord,
but
that is-
here
yes, my lord.
3H4 says that he can go.
My lord.
If he agrees,
Yes, my lord.
so they should in fact go there, not
My lord.
here.
And the Kala is also not made a party here.
No. Kala is made a party or not, but the joint secretary is there.
My lord,
But anyway, he is also functioning as Kala.
my lord,
But the fact that if there is any dispute,
My lord.
it is for them. Because one thing, as per you, this person has a different thing.
that the petitioner is required to go to the civil court. But in the, if you look into the section 3H4, my lord, if it is required to refer, whether when they claim to the Kala, Kala is required to refer it to the district judge.
So then, Kala will refer.
So that point, if
No,
the,
but
if the
it
point is
is- no,
decided, my lord, by lordship issue the direction to that effect, my lord, that will also.
Hey, we still have it. Because my judgment categorically
Yes, my
says
lord.
one
Lordship has
thing,
also decided
that
this issue in
once there is a dispute, Kala,
my lord,
the
lordship
Kala
has already
cannot
decided the
decide
issue,
it.
my lord. Has already, in the T state case, my lord, report, T state case,
Yes,
lordship has
yes.
already decided. I will already gone.
That is the Jalan Nagar.
Yes, my lord.
If where several persons claim to be interested in the amount deposited under subsection 1, the competent authority shall determine the person who in its opinion are entitled to receive the amount payable to each other. If any dispute arises to the apportionment of the amount or any part thereof, or to any person to whom the same or any part thereof is payable, the competent authority shall refer the dispute to the decision of the principal civil court of the originator within the limits. So therefore, it is for you to decide.
Fine. We have to stand it. Well, but in this case, my lord, particular, in that particular Dagan, there is no dispute. Dispute is in respect of another Dag, another Patta, my lord. So, if your lordship, my lord, to pass an order, my lord, we can, my lord, dispose of it like that also. We will refer it, my lord. Then that can also be decided, my lord, regarding the forgery. And we have filed the affidavit, my lord, also. Page 67, my lord, paragraph 7. Paragraph 7, my lord, page 67.
By National Highway Authority. It is by response number 3.
Lordship, I am appearing for 1 and 2, Lordship. In our affidavit also, it has been cleared. Paragraph 5.
With all your means,
One.
problem arises with all these things is the page number is wrong.
Page number
So Mr. Chuti, you are appearing for response number 4.
4, my lord.
4's affidavit, when did you file?
We have filed in on 29/7/2024.
29/7/2020. No. This is filed by response number 3. 1 and 2. Ah, yes, it's what. There are 7. So this notification. His serial number is what?
173, not the petitioner, my lord, that particular dark petitioner claim. Page
The
24,
village is mentioned in Langti book. Langti book,
not long.
then
Naharjan,
Naharjan.
Naharjan, my lord. Page 20.
But the
Naharjan.
petitioner's land is what?
Petitioner land is, my lord, they see annex, my lord, the petitioner, that is, my lord, is,
Your notification does not say NC.
my lord, not here, page 29, my lord, 28, her patta, see annex, my
No,
lord.
no, no. Kindly see page 20 of the writ petition. Your village says village Naharjan.
Naharjan, my lord.
It does not say Naharjan NC.
My lord, there are two villages, my lord. They are in these two villages, my lord, two villages are included. Naharjan block number 1 and Naharjan NC. So that in the printing it only Naharjan was printed, my lord.
So then
But-
it is wrong.
My lord, that includes two villages. We have clarified it in other cases also.
No, no,
The
you
two-
cannot because here it is
yeah,
Naharjan, her land will go.
My lord.
Then
So so she claimed that her village.
because your notification does not say Naharjan part 2.
Yes, my lord. The notification includes only the village Naharjan, but there is no village Naharjan like that way. There are two villages, village Naharjan block number 1 and Naharjan NC. So both the villages are included as village
No,
Naharjan.
no,
my lord.
kindly see her patta.
My lord.
Her patta, kindly see it is given in village Naharjan. Then,
Then
why you are
another
saying that it
person,
is
my
not-
lord, his village,
then kindly see her Jamabandi,
my lord,
which is also Naharjan.
my lord.
Then where is the Naharjan way? Anything else comes in?
We have, my lord,
Everywhere Naharjan, then she's right.
but that is my lord, the confusion, and so she find the repetition and the claim before us, my lord.
No,
That-
no, why your statement at paragraph 7 seems to be wrong. Petitioner claim compensation in respect of patta number so and so of village Naharjan and the description of the land published in the Gazette is in
Particular
respect of
PP number is
Naharjan so
different,
and so
madam.
NC.
Well, PP number is different. Petitioner's PP number is 30 and the publication is respect of the PP number 70, my lord.
So understood, then petitioner's land should not be disturbed.
My lord, that she is not, see, as per our record, she does not have any land.
Why do you want the setting aside of this? So that your land cannot be taken without following due process. That's all. So your land, which is at patta number
70,
number
patta number 30, dag number 70.
30 should not be disturbed by them. Make it very clear.
Right.
Because this notification is only in respect of patta number 70 and of dag number 70. Your land is at dag number 30 and
Dag
patta
number
number
70, patta number 30.
patta number 70.
Patta
So
number
under-
30, Lord.
Huh?
Patta number 30, dag number 70.
So the dag number, patta number is where? But the dag number 70 of patta number
30.
That
30.
number 70.
So patta number 30, it should not be disturbed. Parents, why will you be entitled to any amount? They say that they are only doing some other village. Very well. He categorically mentions that it is not your land. So your land should not be disturbed. We make it very clear. The dag number 70 of patta number 30 of village Naharjan, Moza, Gorjan should not be disturbed. And this notification under no circumstances would apply to your land of this.
And Lordship, my record, my submission also, my lord, if Lordship.
Lordship, may I pray that the matter be taken up on Friday?
Madam, you are getting a win-win.
Yes, Lordship,
If
but
in any manner they come in, the notification is almost set aside for insofar as your land is concerned. Because of his submission. I'm giving you the entire relief.
Lordship, but
You don't want the relief.
yes, Lordship, I want the relief, but
This is what you are asking. That the notification insofar as your land is concerned.
There is no
should go.
notification. There is no notification, my
So
lord.
they
Just my
say that
submission.
this notification has nothing to do with your land. So your land should not be disturbed by Kala.
My lord, then claimed by the petition.
And this notification, by this notification, the land of the petitioners have not been acquired. So with
Right.
this declaration, you are out. Notification remains, but you are not disturbed. But you want that land, your land to be acquired.
Lordship, it should be with us. With us.
So it will remain with you. After this, Karbi Anglong may have to notify again.
Will not notify.
May I pray that the matter be taken up on Friday, Lord?
And then when this court is giving you all the relief you don't want.
Then we will also file the additional affidavit that the claim of the petitioner on the basis of that particular is a forced one.
Huh?
Is a forced one, my lord. So we'll bring it on record, my lord.
Which one?
The patta submitted by the petitioner, original patta submitted before us, my lord, is a forced one, my lord.
So you are
There's
saying
no-
that
Yes,
patta
my
number
lord, we have-
70
we
is a
have not
false
issued
one.
any patta, my lord. We have not issued that particular patta on the basis of which the petitioner claimed compensation. That is our categorical statement, and we are coming to a conclusion to that when the petitioner submitted the original patta for verification.
But why are we concerned with that? No, we are not concerned with that because why should we? Madam, you take this order. Later on, after that, if they file an affidavit, you are in more trouble.
And in similar cases, we have sent it to a forensic laboratory and we have got the report and we have filed a complaint before
Mr. J. Sutia, the learned counsel appearing on behalf of the Karbi Anglong Autonomous Council submits that there are certain instructions awaited in certain matter, awaited in respect to the patta of the petitioner. And he submits that some time may be granted for filing an additional affidavit. To list the matter again on 4th of December. In the meantime, the affidavit be filed by the Karbi Anglong Autonomous Council.
We have already filed it. Respondent one and
Madam, I don't say anything unless you argue. If you want your name, you give your names in the slip, they would put it in golden letters.
So I'll pursue it by 15th. I'll try my best to get it done.
When?
Let the matter come up after 16, 17. I'll pursue the chief secretary because I
Mr.
have
Advocate
immediately
General.
written letter to chief secretary also.
Mr.
To Lordship
Advocate General.
Club.
I want to request you in another matter. That is item number. Yes, Mr. Solia, you are appearing in another matter, no? No. That morning matter, you asked for 2 weeks' time, no?
The item number
35, yes.
35.
35. Mr. Advocate General, kindly see to this item, it is done, because of the fact that this was an amount, she was a handicapped child. So some amount has been given, everything has been done, it is, the process is being delayed. And this, you see, the medical department is doing a lot. I'm getting monthly, every quarterly reports, I've been getting everything that she has been checked. This was a child who, on account of her vaccine, some problem with the vaccine, she developed a particular disease. It's a very difficult term to say, but and now she has been like a palliative.
The detailed order, I think I
Yes,
have gone through that.
yes. So
Yes.
that amount which is there means I have disposed it of and I have given that if that amount is not given again to file, I have been filed. And the government said that, okay, they are doing it, and the matter is getting delayed. Can you look into that?
Because when Lordship passed, I gone through that order.
Yes, because this
Wanted
is
it to
one
be-
in a million case this happens. Never happens.
It's the rarest,
often.
one of the
One
millions
of the
case.
rarest case which has happened.
Lordship has detailed here
Yes,
whole illness.
in-
I have gone.
In a country like India, this is one in a million, not in 1 million. It has never happened like this because of the vaccines he developed at the age of 18 months or something like this.
And she comes from a very poor family. also.
Yeah, very poor.
Not-
But she's only a vegetable vendor. He is. Can you see to?
I remember this. also.
Yes, yes.
We'll look into that also.
Mr. D. Soikia, the learned advocate general appearing on behalf of the state of Assam, submits that that pursuant to the orders being passed by this court, the proposal for sanction and release of the fund have been sent to the Standing Finance Committee for concurrence towards sanction of the proposal. It submits that upon receipt of the concurrence, the financial sanction will be issued and the sealing demand shall be placed before the Finance Budget Department for release of the funds. In that regard, he submits that some time would be required in this regard. List this matter again on 25th of November, on which day an update shall be given as to whether the funds have been released to the petitioners. The document which have been placed before this court is kept on record and marked with the letter E.
Item 27.
Reference number 5 and 6 is some settlement.
Anything completed?
Of the compensation.
Left out, my lord. We are sorting it out within 3 weeks. Within 3 weeks, my lord, we'll sort out the issue.
It has been submitted by Mr. J. Roy, the learned counsel appearing on behalf of the IGGL, and Mr. A. Kolita appearing on behalf of the NRL, that negotiations with the petitioners are at the fag end and almost complete. He therefore submits that 3 weeks' time may be granted in that regard. List this matter on 27th of November for an update.
See, 29%, 27, also I have some problem.
29th of November.
28.
I please your lordship. Lordship, additional affidavit is filed on today as per the order of this honorable court.
It has been submitted on behalf of the petitioner that an additional affidavit in pursuance to the order dated 7/8/2024 has been filed today. However, the same is not on record. List this matter again on 4th of December, bringing on record, the registry shall bring on record the said affidavit.
29.
We have been directed to bring certain instructions as because the incident occurred in the year 2019. But the regulation of 2023 was there in the report of the Chief Electrical Inspector. So clarifying that a new inquiry.
Oh, yes.
But lordship that.
Here you came up with an inquiry report in respect to a law which had not come into force.
According to
Then-
Lordship, they have sent us the enquiry report, but I have seen Lordship, the same enquiry report they have sent. Lordship, may I pray Lordship, sometime so that I can,
My lord, it was, the same report was sent earlier date when it was asked to
No,
raise
on-
inquiry.
as because your Lordship just, that pursuant to that order, this report is dated 25/9/2024, after the order of this honorable court, after receiving the letter from our side, Lordship. I will clarify this,
So they have come up again, because here the electrical accident had held that both the petitioner's husband as well as APJ were partly responsible on the basis of a regulation which came into existence in two
by
thousand.
clarifying all these things, I will again send a letter to them, Lordship, so that whether that this specific question I will regarding this, your Lordship's order, Lordship, that whether in 2019, how they can tangle this, Lordship,
In
2020.
fact, Mr. Counsel, there is one judgment passed by me wherein it was held that there was a contributory negligence. Then also I passed an order directing payment of rupees 4 lakhs to that person concerned. You want that AARC compensation as per Schedule A, isn't it? Of 4 lakhs. But there is a judgment passed by me wherein the APDCL had taken a stand that it was contributory, so there is not liable, not likely to be payable. I say that this is a welfare legislation. Secondly, I say that here only it says that there is a negligence. It does not say anything about if there is a little bit of negligence also, the person will be entitled. Find out the judgment. Mr. B. Chaudhary had appeared on this side. There was another counsel. This court, by an order dated 19/8/2024, upon perusal of the electrical accident report, opined that the said electrical accident report was not in conformity with the well-settled principles of law, taking into account that both the petitioner as well as the APJCL have been held responsible on the basis of a law which had not come into existence as on the date of the accident. Accordingly, this court had directed the respondent number 1, 4, and 5 to obtain a fresh inquiry report on the basis of the laws which was prevailing at that relevant point of time. However, till date, no inquiry report has been placed before this court. Under such circumstances, this court fixes this matter again on 27th of November 2024. The electrical accident inspector is directed to file an affidavit bringing on record the fresh inquiry report without fail on or before next date.
Receive that report, but that is similar to that earlier report.
If you say that, if you want to say that, I will say that this electrical accident reviewer does not understand or they have not been conveyed, whichever you want. Let us
But
not,
even then, Lordship, I will.
let us not
Lordship.
certify the what you call the knowledge and the knowledge of the electrical inspector.
30.
Wait, your Lordship. My lord, till date, no affidavit has been filed, even after repeated, my lord, earlier 3 operation, my lord. And this is regarding, my lord, rejection of OBC certificate by the European letter is 24, my lord.
The minutes of the meeting, your lordship, to discuss the status of manual community in
Madam, this is a case of 2023. Does it require so much time for filing an affidavit? Forget about the meeting. I'm not concerned. When a writ petition is filed, you are put to notice, you have to file your reply. We are not concerned with what meeting your government keeps on holding. Here is a specific question out here as to whether the petitioners herein would be entitled to the OBC certificates or not. If they are not, you have rejected it. The rejection has to be based upon certain good reasons. And if you have good reasons, fantastic. Put it on affidavit. If you don't, say it. You don't. We pass appropriate orders. But you can't keep the petitioner standing just for a year.
outside, your lordship. In file, bringing the minutes of
You bring whatever minutes out there, bring it. We're fixing it on 28th of November, 20. File your affidavit. It is seen that the petitioners herein are aggrieved by the rejection of their application seeking OBC certificates by the Deputy Secretary to the Government of Assam, Welfare of Plain Tribes and Backward Classes Department. This court had issued notice as far back as on 27/6/2023, and almost a year and more than a year have passed by. Until date, no affidavit has been filed by the respondents. Under such circumstances, a final opportunity is being granted to the respondents to bring on record their stand by filing the affidavit. List the matter again on 22nd of November. The affidavits be filed by 20/11/2024 without fail.
31.
Oh, this matter. What is there?
So this sir will be is on deck. Can be possible for timing.
Not timing, we'll have it some other day. Yes, we asked you to file an affidavit. You filed it.
On behalf of the DFO, he's compiling a report, lordship. We are seeking 2 more weeks,
What 4 weeks? I gave you more than 4 weeks.
2 more weeks, lordship.
This court was not here for a month.
A report is being compiled, but
We asked you to file an affidavit. Herein is directed to file an affidavit as to whether the resorts, namely so-and-so, 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 fall within the ambit of the core area of the Tiger Project, and if so, what steps have been taken by the forest in regard to those resorts? What is wrong? Why can't you file it? These aspects were made the very allegations out there in the writ petition. So you are aware of these allegations.
Here's my instruction.
Your instruction is there. Your instruction doesn't mean that it will continue for long. And this case has been specifically endorsed to me. It needs to come to a conclusion. We consider it that you have not taken any action against them. And as such, these fall within the area as has been stated by the petitioners. And then we say that it is absolutely a discriminatory and arbitrary actions on the part of the Forest Department, and we set aside that. Anyways, your rule 9, the clause 9 thing does not hold water because of the fact that your clause 9 was based upon the order passed by the learned single judge in the other matter, which have been now clarified.
But that clause 9, it has a wide ambit.
It didn't have, it is said that it becomes unviable. It doesn't become unviable now because the order categorically says that the petitioners can do everything.
But that is what lordship, but in our affidavit, we have given the reasons.
You are bringing in some other reasons. Now, these are all non-forest activity. These are forest activities which are being carried.
No, not at all.
No, these are the permitted.
Yes,
Non-forest
permitted, but
activity.
the subsequent to notification of the government of India, no permission is required under section 2 of the Forest Act. Well, they are permitting resorts to come up. People are advertising in the name. And we only enable our members, Milan. We do not allow XYZ to come and stay in the area.
We have passed an order not to create any third-party rights, no? We asked you to file the affidavit by 22/10. Then
We had issued a letter, but
we're not asking, then we have to consider it. That as if that the government has nothing to say. You have not done anything to that effect. Have you done anything as regards conversion of these areas? Have you taken any action against, these are forest areas out there with these, all these companies are, all these various resorts coming out there. Did you take any permission from the central government in that regard? Isn't it the mandate under section 2 of the Forest Conservation Act?
from my understanding, some NGT directions were recently passed.
Oh.
Certain directions by the Honorable National Green Tribunal. Those were also passed regarding the Namiri Reserve Lordship. So that compliance report is also something that DFO wants to rely on, which is why Lordship is sought some time.
No, have you taken the permission from the central government in regards to these resorts?
Those resorts specifically, Lordship, we have sought for written report, but
No,
that is
no,
not
have you
received.
taken any permission from the central government, which is required under section 2? If you have not taken, isn't it absolutely a violation?
It would be, Lordship, it was not taken.
More particularly in respect to this certain matters which have been taken up recently with the judgments of the Supreme Court in regard to forest. Now, here is a case where they are having only on tents, which was permitted, and this has been done on the basis of the funding also available from the NEC.
And basically, we are on to angling, encouraging angling, nothing else.
Better, why don't you move the Supreme Court? Ask some association to move the Supreme Court in the T and Godavari matter. Look here, we want to cancel that thing, nothing is happening. Then the Supreme Court may ask you about all these things. Do something. Yes, Mr. Chaudhary, when we can fix it and dispose it of on our court. On I
My lord. Other than 20 to 24.
let's have it on 19th.
Yes.
You bring on record your affidavit by 13th.
And we'll file reply if any.
It is seen that pursuant to the order passed by this court dated 26/9/2024, the Forest Department of the Government of Assam have not filed the affidavit as directed. Under such circumstances, this court, for the ends of justice, gives an additional chance to file the affidavit by 13th of November 2024. It is observed that in the circumstance no such affidavit is being filed, it shall be presumed, and this court may presume adverse may not filed. This court would presume that the statement, the contents of paragraph number 4 of the order dated 26/9/2024 may presume that the Forest Department have not taken any steps in respect to those resorts, details of which have been given in paragraph number 4 of the order dated 26/9/2024. So it is further observed that in the circumstance the affidavit is being filed by 13th of November 2024, the petitioner would be at liberty to file the reply. First, list this matter again on 19th, when did I finish? 19th.
Give the public. Lordship, in this matter, the respondent number 2 and 3 have filed an affidavit in opposition, Your Lordship. I need some time to file a reply, Your Lordship.
The counsel appearing on behalf of the petitioner submits that pursuant to the affidavit filed by the respondent numbers 2 and 3 on 24/10/2024, the petitioner would file a reply to list this matter again on 20/11/2024. In the meantime, the affidavit, in the meantime, the petitioner would be at liberty to file.
Okay.
I pray for 10 days time to file the affidavit over construction.
Mr. H. Gupta, appearing on behalf of the respondent, submits that he may be granted 10 days time for filing the reply. So, affidavit in opposition. List this matter on 22nd of November. The reply be filed by 20/11/2024.
This is non-payment of contractual liabilities, my lord, for carrying out an water supply arrangement at government's dental college teacher.
Who has taken your water and not paid?
Work order was issued by the DC department, but work was done for the dental college, my lord, health department. So now liabilities is from the health department. Any last annexure, my lord?
Yes. Why you're not
Lordship,
paying the money?
Lordship, I have received one communication whereby the Director of Medical Education has proposed given to the government for payment of them.
So you admit the amount.
Yes, sir.
So you dispose it off? Heard Mr. N.J. Katonia, the learned counsel appearing on behalf of the petitioner. Ms. S. Sharma appears on behalf of the Health Department of the Government of Assam. As well as anybody else? Oh,
That's-
Mr. Ivo Tagore appears on behalf of the PHE department. The petitioner herein has approached this court, being aggrieved by the inaction on the part of the respondent authorities in not making payment of an amount of rupees 39,10,890, to which the petitioner is entitled to for carrying out the work or pertaining to independent water supply arrangement at Government Dental College, Ghungur, Ghungoor, Silchar, which was awarded to the petitioner by work order dated 5/4/2023. Full stop. From a Peru, full stop. This court had issued notice on 31/7/2024. Ms. S. Sharma, appearing on behalf of the Health Department, submits that the Health Department duly, appearing on behalf of the Health Department, submits that the Director of Medical Education have already written to the Medical and Research Department of the Government of Assam for the purpose of approving the financial sanction and release of FOC for an amount of rupees 39,10,892, which is required to be paid to the petitioner. He further submits that from a perusal of the communication which was issued by the Director of Medical Education to the Additional Secretary to the Government of Assam, Medical and Research Department, it is clear that the respondent department duly admits that the petitioner is entitled to the amount of rupees 39,10,892. Full stop. She, the learned counsel for the Health Department, further places before this court an instruction dated 16/8/2024, wherein the communication issued by the Director of Medical Education dated 8/8/2024 have been enclosed. The said communication is collectively kept on record and marked with the letter X. Taking into account that the amount in question had been duly admitted, and there is already a direction, a request for issuance of the financial sanction as well as release of the FOC. This court is of the opinion that the instant writ petition can be disposed of at this stage, thereby issuing appropriate directions. Accordingly, the writ petition stands disposed of, thereby directing the respondent authorities, more particularly the respondent numbers 1, 2, to take appropriate steps for disbursing the amount of rupees 39 lakhs 10,892 to the petitioner, to which the petitioner is entitled to. The same be done so within a period of 6 months from the date of issuance or the date of serving a certified copy of the instant order to the respondent number 2.
Obliged.
Item 36 for order.
Yes, what is it?
Yes, it's watching. And it's what is related to non-payment of contextual bill, my lord.
What is the order passed? What are you asking for compliance? At the same time, level shall pursue the matter of releasing the security to the concerned. Yes. Why you're not paying?
Here, Lordship, as per our instruction to documents, the administrative approval and the technical sanction is could not be traced because of the bifurcation of the division.
You should have thought out all these things at the time of the writ petition.
So now.
You have categorically admitted that the petitioner is entitled to the amount of rupees 4,01,000. Why haven't you paid? Who is the person concerned? The direction is given to the directing the superintendent as well as chief engineer PhD to release the statement. Why haven't you paid? We are not concerned. Here there is a finding of fact to the fact that he is entitled to this amount of rupees 4 lakhs. You have not paid. Order was passed in 2019. We are in 2024. It doesn't look nice on the court. So we ask the person, the chief engineer, the present chief engineer and the superintendent engineer to be present in the court to explain as to why they are not paying. That is the way in your Chalo. We are not concerned to that effect. Who pays or not pays, I'm not concerned. Why haven't you paid that? No. The instant writ petition has been filed, being agreed for alleging non-compliance to the order dated 1/2/2019 passed in WPC number 7324/2017. From a perusal of the order dated 1/9/2019, it appears that both the superintending engineer PhD Nagaon Circle Hosai Division as well as the chief engineer PhD department were directed to release the amount of rupees 4,01,368 to the petitioner within a period of 3 months from the date of receipt of the certified copy. The materials on record show that the said amount, that the said certified copy was duly received both by the concerned superintending engineer PhD as well as the chief engineer PhD. However, till date, the order had not been complied in spite of a passage of 5 years have passed by. The act on the part of the respondents concerned clearly shows an absolute dereliction, clearly shows, prima facie shows that the orders passed by this court have not been complied with, which is prima facie shows to be an attempt, prima facie shows to be an attempt not to comply with the order passed by this court. Accordingly, this court fixes this matter again on 11th of November 2024. The present incumbent chief engineer PhD department as well as the present incumbent superintending engineer PhD Nagaon Circle are directed to apprise this court as to why contempt proceedings should not be issued against them.
It's on 11 of November, not available.
Madam, don't wait. Don't worry. Take care. You want it on 13th?
14 November.
14, no. 13th. What is this?
extension of interim order.
What?
In fact, there was an interim order, my lord, but then it was to a specific date. During the proceeding of the case at one particular point of time, that was not specifically extended. And irrespective of that, my lord, the issue survives because whatever was there, because the case, my lord, of the petition
What
was that-
interim order is this? What is the case about? Indian order is issued the malafide intent causing responsibility of building occupation. Yes, what is the case about?
Once you got in the call of the issue of a notice to the petitioner to demolish the building.
Then?
Their conclusion is that I have no permission. Unauthorized the construction.
You have a permission. Where is that?
They are of 1984.
Where is that? Let us see the notice which was issued. Page 39.
Order passed on the. So,
Where we have put in the nature of the money and the whole, nature of the construction also the location of the man.
Final order passed on lordship for page number 41, annexure 7 lordship, 29/8/2019.
So you had a permission.
Page number 26 is my permission. Page number 26.
20
26.
for construction, your application dated demand proposed so and so. Yes, government, GMC, who are you? Mr. Pato?
I am the builder. Subsequently, that land was given to me in a development agreement. As per that development agreement, second position of the land was to be handed over. However, this particular building, irrespective of whether the permission is there or not, that was to be demolished after I construct the building and allotment shops inside the building premises. To that extent, my lord, there was a civil suit also. There was a first appeal against order in the High Court. There was a mediation agreement between the parties. The shares and everything was, my lord, worked out. And accordingly, the matter had come to a rest. But then this particular building, my lord, still remains because this particular demolition notice
Yes.
is under
respondent,
challenge and there is a.
GMC. You have the habit of taking instructions from others. That day I passed one order. Somebody telephonically calls also, the GMC does action.
Yeah, well, this construction was with NOC of.
First and foremost, he submitted a reply.
No.
Yes, he has submitted a reply. Reply, he has said that I have a permission of the year 1984. Now, under such circumstances, isn't it your duty to pass an order saying that permission which is being shown is not there. There is no permission as such. You have not said anything. There is no reasons outside. It seems to be a cyclo-style order without any basis. Even you are not saying where is the infraction, where is not. Whether it was in 1984, there was anything given or not, there is no mention. Kindly see.
In fact,
Your notice categorically says
page number 41.
that you have here, no, page 39. You are hereby directed to discontinue undertaking work or erection of here. This is to be a cyclostyle here.
39.
Where is the
It had
document?
1 and 2 notice.
That is
right?
your notice.
So called.
So asking the notice was served upon you, which was not responded to. You are therefore, this was done in the year 2019. You are therefore directed to discontinue consideration if you do not submit an explanation as demanded above, or if the explanation is found under the year will take. Now see, he replies to the effect that, you see, it is clearly mentioned that the building was constructed with NOC number Iman, and the earlier notice dated so-and-so was issued in my name, and I have filed my reply, which was duly acknowledged by the GMC. Now, where is there mention anything? See, it is asking you to discontinue an Iman, and whereas you have not produced the NOC. Now, this NOC is there. Did you produce the NOC? Did you produce the NOC?
It is an X, but it is there. In the reply, there is no NOC. Only the number has been given.
We will look into page 26
Page 26.
as to whether that is going to take a decision.
Not-
You dispose it out.
I have also put a query, my lord, because in 1984, my lord, this laser printed NOC formats, my lord. It itself raises a suspicion, my lord. The format in which it is printed of 1984, the font and the printing used, my lord. It is a suspicion, my lord, that I have queried, my lord, of course. The original has never come out of this. But the difficulty for me today is because the building is still there, the
I'm not
frontage,
concerned. Who are
the
you?
frontage of my building.
Kindly don't imply a motive of the GMC by making further submissions. The GMC is to decide, let them go and decide, taking into account as to whether this actually is there or not, it is a fake or not, you will have it on records. Forget about the reply, I'm not concerned. You want the matter to be delayed out here, I'm not going to delay it. The question is simple. Let them look into it. You are concerned that there was a permission and as such you have not constructed, not newly constructed. Fantastic. Now the question is, he has, let the GMC also has not. We set aside that order and direct them to pass a fresh order.
Straight away say that particular page number 40, that is line. Specifically, they're giving the NOC number. That will examine and pass order.
So it is there in page number 26.
26 is not clear, my lord.
Now they'll give a clear copy. Provide a clear copy.
They've given the number.
Huh?
They've given the number. Specific
And
number.
whether there is number or no. Laho. I should be good.
For a 2-year concept, my lord, we got stuck in the process because now they are not removing that structure, the frontage of the building is blocked.
Also, GMC
Which as per the development agreement, my lord, should have been removed.
agreement.
Is it your petition?
No, my lord, definitely, I cannot seek any relief here.
Do I look
But
any,
but
Mr. B. Pathok, do I look anywhere that I am a civil judge? Is it a suit? No. Go there. It's just across the street. Laho. You are only concerned with the order. You cite aside the order directing them what is wrong with it. Matter over. Simple case. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. S.C. Bora appears on behalf of the GMC. And Mr. B. Pathak appears on behalf of the respondent number 7. The petitioner herein is aggrieved by the order dated 28/9/2019, whereby the Commissioner Guwahati Municipal Corporation had passed the order under section 337(3) and 337(a)(1) of the Guwahati Municipal Corporation Act 1971, for short the Act of 1971, whereby there was a direction for demolition, sealing the unauthorized construction. The case of the petitioner herein is that the order dated 29/8/2019 clearly shows that the said order was passed without proper application of mind. and as such, the impugned order is required to be interfered with. It is further seen from the materials on record that the petitioner was issued a notice on 8/1/8/2019 by the Commissioner GMC, whereby it was informed that on 17/5/2019, another notice was issued to which the petitioner had not responded. Further to that, the petitioner was asked to give an explanation as regards the unauthorized construction of the RCC building. It is further seen that pursuant thereto, the petitioner had submitted a reply on 6/8/2019, wherein it was categorically mentioned that the petitioner was granted a building permission bearing NOC number GPL/551/85/8 dated 21/9/1984. It was further mentioned that on the earlier occasion also in the year 2015, another similar notice was issued and the petitioner had duly submitted a reply. In addition to that, the petitioner have also mentioned that the petitioner have never constructed any building without obtaining permission. And it appears that time and again, the petitioner has been harassed at the behest of certain vested interested persons. This court had further perused the impugned order dated 29/8/2019, which shows a perusal of the impugned order shows that the Commissioner Guwahati Municipal Corporation have not taken into consideration the reply, in as much as there is not a single reference as regards the permission bearing NOC number GPL/551/85/8 dated 21/9/1984, which have been duly referred to in the reply submitted by the petitioner. In addition to that, it is also seen from Annexure 1 to the petition that the petitioner have enclosed the said permission full stop. It is further seen that the a perusal of the said permission shows that the petitioner had made an application on 3/8/1984. And along with the permission, there is a copy of the approved plan also. Taking into account that the impugned order dated 29/8/2019 does not mention, that does not deal with the permission, which have been duly referred to in the reply. This court is of the opinion that the impugned order dated 29/8/2019 suffers from non-application of mind, and accordingly, the same is set aside and quashed. This court further takes note of the submission of Mr. S. Bora, the learned counsel appearing on behalf of the GMC, who submits that the petitioner be directed to submit a clear copy of the permission which have been enclosed to the petition along with the approved plan which have been duly mentioned in the permission itself before the commissioner GMC, so that the notice which was issued on 1/8/2019 by the commissioner GMC could be brought to a logical conclusion. Full stop. Taking into account the above, this court, upon giving an anxious consideration, is of the opinion that in order for the commissioner GMC to decide as to whether there is a permission or not, there is a requirement that the petitioner should submit either the original, you have the original.
Said to be lost, my lord. When we question that foundation, in reply, they say that the original is lost. Yes. Yes, lost.
Original is lost. To submit a better copy of the permission, and further also produce the approved plan which forms a part of the permission. Also, the same shall be done within 10 days from the date of the instant order. On the basis of the same, documents being submitted, the commissioner GMC shall decide the proceedings initiated on the basis of the notice dated 1/8/2019. With the above observations and directions, the instant petition stands disposed.
He may be also considered
Why?
because he has lost his.
Nobody.
title over the land.
You are nobody.
My lord, his-
Absolutely no.
His title over the land is gone now.
I'm
His
not
exclusive
concerned
title.
whether he has a permission. You see, there's a difference. Whether he has a title or not, you are no business person to say. It is for the deputy commissioner to say. You don't have the deputy commissioner nearby.
Because of the development agreement that they themselves have cleared it, my lord. They have
You
themselves
go
not-
file suit. If I want, I can say that and I'll say that no. It will have a further. The GMC commissioner anyways have done something in your favor. So obviously he will hear to you. Who there? Mr. Pathak, with that, you'll get that order. It will already come out. His permission which is there, it will be very difficult for him. Don't worry.
38.
Yes, what is this?
Worship, in this matter, there are certain developments that we were not aware of, Your Lordship.
Huh?
And there are certain developments in this matter that we were not aware of, Your Lordship.
Who is not aware?
We were not aware of it.
Now you want to withdraw?
Not withdraw, Your Lordship, we need some.
You are,
consent
huh?
from our bank, Your Lordship.
What?
Either we will find a fresh new writ petition or an amended writ petition. Your Lordship.
What is your case about?
The case pertains to the trigger of the allotment of the retail outlet of a dealership in the HPCL petrol pump, Your Lordship.
Retail outlet. HPCL. Who is for HPCL? Oh, yeah. Mr. Bottago. Which one? What is the problem here? And that will challenge. We are 226. Don't worry with that. Huh? So they must be getting used to how much of challenge they will make. But I'm concerned, what is the point involved? Why this has come up for orders?
My lord, today we have filed our affidavit on the rest number 7 I'm appearing. And I filed my affidavit today.
Is there a stay?
No stay.
Oh, they want to take time. We'll admit it and list it for hearing on the usual course. You have this petrol pump for how many years? 30 years?
Yes, 30
Or
years.
19 years?
30 years.
No, you are giving for how many years? 30 years? 30. Huh?
I'm operating since like 2025, 2021 I'm operating.
Okay. Taking into account that the affidavit in opposition has been filed by the respondent number 7, the counsel for the petitioner seeks some time for filing a reply. Full stop. Accordingly, list this matter again on 27th of November. In the meantime, the reply be filed.
20th November, I'll go to Gaya for the Gaya Sapta and I'll come back on 1st of December, my God. Any date after that, my
Okay, you come on 25th,
my
25th of November.
20th November.
Lordship, there is some difficulty in 25th November.
What?
There's some difficulty on 25th November, Your Lordship. Can it be after 25th November?
You file your reply, madam.
So Lordship, make it in the 3rd, 4th, 5th December, anything like that, my Lord. First,
We'll have it on 11th December.
after
How we do one thing? Would like to file a reply. So taking into account the above, 4 weeks' time is granted to the petitioner to file the reply. Yes, what is this?
Your Lordship, the petition.
Complied?
Complied, Your Lordship.
Complied.
Because Your Lordship, the order which they have challenged in the contempt petition, subsequently, that particular order has been challenged in another writ petition, that is the second round of litigation. That is WPC 1863 of 2023. And that particular writ petition has been disposed of, Your Lordship.
So nothing remains. Mr. G. Bodler, appearing on behalf of the respondents, submits that nothing remains in the instant contempt proceedings, taking into account the order on the basis of which the instant application has been filed no longer survives. So taking into account the above, it appears, therefore, that the petitioner has also lost interest in the matter, and as such, the petitioner have not appeared on 7/6/2024. In that view of the matter, the contempt proceeding stands dropped.
Okay.
May I pleasure?
Yes, what is this contempt for?
One payment of outstanding bill, Malad. I have received the instruction, Malad.
Why you are not paying?
For the Tamse early, Malad. These have been prepared. Tamse early, these have to be prepared. These have been prepared against that particular. There are 1,000 more than 1,900 persons. The soft copy I have received it, Malad. But this person's name appear in 3-4 places, Malad. I could not find out the exactly which is the contract here done.
You were directed to pass a reasoned order. Kindly see paragraph 4 of the order. Is it another one? Which is the actual order? Huh?
They have passed the reason order.
Oh, this one. This case. All fake. Huh, Mr. Bora?
This,
Where all these suits are pending?
No, Malad, that is not suit.
This. Is he not asking from 17/12/2021?
the order has been passed.
Legal non-compliance for what? 17/12, yes.
Of the
I understand, Mr. Bora. You see, these matters, nah. There was they said that Kamsir Ali. Now what has happened?
This is non-availability of fund, then the fund has invested. The fund has come and this has been prepared. Not in the meantime. In one of the cases, it is.
So as of now, you have already figured out, put the petitioner in the list. And then when the fund is received,
1,900 persons are there. And his name is there in 4-5 places, my lord. I could not read a soft copy, I have received it.
but one of the places, the petition is 1,643. So I have to compare it with, they have done many contracts.
You have filed the affidavit. Mr. Elbora submits that he has instruction and he would file an affidavit. This matter again on 11th of December. In the meantime, the affidavit be filed.
Okay, my lord, I have one submission and they allow me.
Huh?
They are saying that they have prepared the list as per the temporal. When they have prepared the list, that is not mentioned there. Now, in the year 2022, they have,
Mr. Counsel, there is one document out there which he has submitted.
that I have met. They are saying
Let
that
them
yes,
file a reply because there is a message.
Fine.
We'll look into it.
Case also, same person.
Same, na?
Same, I think.
they also, I have filed affidavit there. The region order they have passed
Item number 41,
41.
same order. What about 42? 43? 42 is not there.
I'm not there.
43, my lord. Same,
43, my lord, I need instruction, my lord. If it's on GMC, not BTC, my lord. It's a part of part payment has been already made.
Page 15, paragraph 7 is the direction. It was passed with the consent of the learned counsel, Mr. Bora.
The full instruction I have not received it, my lord.
It is the bill of 2016, my lord. Now it's 8 years. When page 15, my lord. Direction was given to pay within 4 months.
Balance amount
Mr. Esbora appearing on behalf of the sole contender submits that he may be given 3 weeks time for filing the reply. This is the matter again on 11th of December. In the meantime, the reply will file without fail.
44 and 45.
Losses, and the review petition losses, as per Tina is appearing losses based on length.
Who?
My lord, actually, what happened, my lord, in this case, my
Oh,
lord.
that case, I
Yes,
asked you
that case, my lord.
that we should
What happened,
review
my
it.
lord, I have taken instruction, my lord. I have taken instruction from my client after serving the copy, my lord. What happened?
These
my
are
lord?
cases pertaining to water resource, na?
No,
So
no.
what type of cases are
This
these?
is my lord, 11 lakhs rupees, my lord. 11 lakhs rupees, my lord, yet to be paid to me, my lord. Due to their mistake, my lord, which is a fact, my lord. They have admitted for miscalculation, my lord. They did not make the payment at the time of my second installment. And my lord, that was committed by them, my lord, for acquisition of my land for expansion of the highway, my lord. And my lord, what happened, my lord? They, after passing a lordship order, my lord, we have filed a contempt petition, then they have filed a review. They have said that, my lord, I am totally entitled to get the 11 lakhs of rupees, my lord. But, and they are also ready to make the payment. But the National Highway Authority, there is no any direction.
Ah, that is the one. I
Yes.
remember. Therefore, I said, let me review it.
Yes, my lord.
Once I review it, then I can include the National Highway
Yes,
Authority and pass
and
it. over.
accordingly, my lord, we will amend the repeats.
No, we'll make them a party.
Yes, sir, yes, please.
So once I review it, the contempt will go for a fix.
The death order or the requisition will come, my lord.
This is by Kala, no? The National Highway Authority was not made a party. Now, therefore, they are, although the Kala wants the payment to be made, but the National Highway Authority is not depositing it
Use. They refuse.
because they are not a party.
Yes. What happened actually during the pending of the requisition, no affidavit was passed.
Ah, that is the problem, no?
This is the problem.
How does this 11 lakhs come into the fore?
11 lakhs, what happened, my lord, my land has been acquired at the rate of, my lord, after the verification, my lord, it was fixed at the rate of this 79 lakhs. Entire amount has been paid, first installment and second installment. First installment, they have paid 44 lakhs out of 55 lakhs. And second installment was correctly paid. That 11 lakhs has not been paid due to the miscalculation that has been admitted in the affidavit in the contempt petition and in the review petition, my lord. And accordingly, my lord, after passing lordship's order, they have approached the National Highway Authority. Authority said it is not possible on their part, as per letter, my lord, that letter is enclosed here with my lord. Lordship will find that letter. It will
Actually, while taken revised estimate was made, the earlier amount which should be 55 lakhs, it was written as 44 lakhs.
It is a first step. এখন আমি দিলু রেসপন্স করতে এখন দিলে
The instant review heard Mr. So-and-so, the learned counsel appearing on behalf of the review petitioner and Mr. So-and-so appearing on behalf of the petitioner. The present application has been filed under section file seeking review of the order dated 11/9/2023 passed in WPC number 9534/2019. The learned counsel appearing on behalf of the review petitioner had submitted that in the said proceedings, the submitted that an error apparent on the face of the record had crept in the said order dated 11/9/2023, taking into account that the land which was acquired was a land acquired under the provisions of the National Highways Act 1956, and as such, without impeding the National Highway and Infrastructure Development Corporation Limited, the order so passed would not be in consonance with the provisions of law. The learned counsel further submitted, for the review petitioner further submitted, that for the purpose of for the purpose of an effective adjudication, as well as giving due effect to an order to be passed, there is a requirement of the presence of the National Highway and Infrastructure Development Corporation Limited as the said authority, as it is under the aegis of the said authority that the land had been acquired. Full stop. This court have also perused the communication dated 5/12/2023 issued by the National Highway and Infrastructure Development Corporation Limited, whereupon it is apparent that it is the state authority who, for state authority, wherein it is apparent that the central government had acquired the land for and on behalf of the state authority. And the state respondents, more particularly Kala, had only acted as the competent authority insofar as the determination of the compensation is concerned. This court have also perused, taken note of Section 3H1 of the National Highways Act 1956, which shows that the payment of the amount has to be deposited only by the central government. And therefore, without impleading the central government, an error apparent on the face of the record had crept in passing the order dated 11/9/2023 in WPC number 9534/2019. Accordingly, this court, therefore, upon hearing the counsels appearing on behalf of the review petitioner as well as the writ petitioner, recalls the order dated 11/9/2023 passed in WPC number 9534/2019, and further restores the writ petition to its original file. Accordingly, the instant review application stands allowed. The registry is directed to list the writ petition being WPC number 9534/2019 before this court, before the court for admission. It came up for admission on 13th of November. In the meantime,
My lord, I may be allowed to highlight I.
you see, I cannot do now. You know what to do. Next, contempt in view of the order being passed in the review petition number 120/2019, whereby the order dated 11/9/2023 passed in so and so have been reviewed, nothing further survives in the instant contempt case, contempt application. Accordingly, the contempt application proceeding stands closed. We will dispose of this. Yes. Main petition fund list with this territory.
So do take 14 or 13.
14th, you want it on Thursday? 13th. 13th, you file your IA, na? Because you need to make two persons. One is Union of India as well as the, because you see 3H, one says the central government shall deposit. What mistakes are being done here is that they make the National Highway Authority only. No, National Highway Authority is for them, they require the central government does it.
Yes, it's fine.
So the payment is to be made by the central government. So that MOT will be a part of it. Yes, what is this? Yeah. Now? Have you filed your reply?
We have lordship asked the chief engineer to submit the fund demand as soon as possible. Documents are here, lordship. Fortunately, in this one, the documents are here, so we'll file a reply, lordship.
No,
take it.
don't take it so easily. If I'm not there, it's a different thing. But here I'm there again. I've given enough of opportunities. You are supposed to file your reply. I gave you enough time. So under such we dispense with the appearance of the council and ask them to be personally present when the matter is there. We give them an opportunity of representation through the council, taking into account that they are doing something for the betterment of, means they don't need not, but taking into account that they have taken this court for a ride by not making the payment, there is a direction, there is an affidavit also filed, na? Yes, affidavit filed,
It's not in this case.
not filed,
Not
no affidavit filed. There was a direction to file the affidavit on 29. 1 month has, more than 1 month has gone. So under such circumstances, we construe that he has nothing to say. So now we construe why we should not punish him now. We issue another notice for why we should not punish him. Hold him that he is contempt, then we fix it for sentence. Let him come, be present in the court.
Lordship, our instructions are fresh, lordship.
I'm not concerned why the payment has not been made. Payment has to be made. You have taken this court for a ride by filing an affidavit to the effect. Isn't this the case where earlier also when the petition was filed also there was a direction?
That is another case.
Oh, this is another case.
I don't.
Oh, this is another case. Okay, okay. There's another case, no, where you are there, where that affidavit has been filed by the superintendent, the chief engineer, PhD, na? Ah, lady, where she has wanted to take this court for a ride by saying that this is the amount, which he also said that this was the very amount which you have already stated. But is there nothing to say? You have not filed an affidavit. Prima facie appears that the directions passer has not been adhered to. Under such, this court gives an opportunity to the respondent hearing to explain as to why the contempt proceedings should not be initiated against them. Okay, you have not filed an affidavit. You don't want to file an affidavit.
We'll file it, lordship. Just
When?
weeks. In 2 weeks, we'll file.
13th. Good day. Mr. I. Bottakura, appearing on behalf of the respondent, submits that he has received the instructions in the matter and would be filing the affidavit on behalf of the sole respondent. Accordingly, list this matter on 20/11/2024. The affidavit be filed by 18/11/2024. It is observed that if the affidavit is not filed, this court shall proceed to the next stage of the contempt proceedings.
Please, your lordship. Also, I have filed my wakalatnama today.
Oh, very good. What is the case?
Lordship, the tendency says, 8 by the order by which this one I will go directed to, dispose of the representation filed by the petitioner in connection with the compensation. claim by the
Yes, madam. He submitted the representation on 19/10/2023, and you were supposed to pass an order. Have you passed the order?
First, it is in process. We have already filed in, it is put up in 2nd November 23.
Have you were to pass the speaking order? Why don't you pass that order? What is wrong? Simple question is, you are to pass an order. That's all. You were given 6 months to pass an order. That was in the month of April. We fixed, madam, I don't know any idea. I fix it on 13th of November, or passed out order. Right? If he is agree, if you will challenge that order, but you have to pass the order. I'm not mentioning that you have to pass the order, but I'm letting you know.
Right.
Have you seen the order? If such a representation is submitted by the petitioner within the time specified by this court, then the same be considered on merit, and after proper inquiry, the representation will be disposed of by speaking order within a period of, for a period of 6 months. Now, the question of giving any further hearing to the petitioner has not been mentioned. Why don't you pass the order? He has submitted a representation, pass an order. Miss So-and-so, okay, appears on behalf of the sole respondent. Sole respondent?
Yes.
Sole respondent. Fuster. She submits that she requires some time to file the reply. List the matter again on 22nd of November 2024. By that time, pass the order. Once you pass the order, we close this. If he's agreed by that order, he will challenge it. Done.